Extend a warm and a cordial welcome to all the dignitaries on the dais, distinguished invitees at University Hubballi. As a tradition, let us commence by invoking the blessings of the Lord Almighty by Ms. Lavanya Udupi, student, KSLU Law School.
सच्चिदानंदमय वंदने आनंदमय चिन्मय सच्चिदानंदमय वंदने आद्यन्तरहितने ज्योतिस्वरूपने आद्यन्तरहितने ज्योतिस्वरूपने जगदोदारणे वंदने आनंदमय चिन्मय सच्चिदानंदमय वंदने चेतन रूपदे जगवनु पोरेवा अंतर्यामिये वंदने तेज रूपने ज्ञानदातने वंदने वंदने साटे इल्लदा दया सागरने चिन्मय सच्चिदानंदमय वंदने सच्चिदानंदमय वंदने सच्चिदानंदमय वंदने जय भारत जननीय तनुजाते जय हे कर्नाटक माते जय भारत जननी नदिवनಗಳ ನಾಡೆ जय हे रस ऋषिಗಳ ಬೀಡೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते ಭೂದೇವಿಯ ಮಕುಟದ ನವಮಣಿಯೇ ರಾಘವ ಮಧುಸೂದನರವತರಿಸಿದ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते ಜನನಿಯ ಜೋಗುಳ ವೇದದ ಘೋಷ ಜನನಿಗೆ ಜೀವವು ನಿನ್ನಾವೇಶ ಹಸುರಿನ ಗಿರಿಗಳ ಸಾಲೆ ನಿನ್ನಯ ಜನನಿಯ ತನುಜಾತೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते ಶಂಕರರ ಮನುಜ ವಿದ್ಯಾರಣ್ಯ ಬಸವ ಮಧ್ವರಿಹ ದಿವ್ಯಾರಣ್ಯ ರನ್ನ ಷಡಕ್ಷರಿ ಪೊನ್ನ ಕಂಪಲ ಕುಮಿಪತಿ ಜನ್ನ ಕುಮಾರ ವ್ಯಾಸರ ಮಂಗಳಧಾಮ ಕವಿ ಕೋಗಿಲೆಗಳ ಪುಣ್ಯಾರಾಮ ನಾನಕ ರಾಮ ನಂದ ಕಬೀರರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते ತೈಲಪ ಹೊಯ್ಸಳರಾಡಿದ ನಾಡೆ ಟಂಕಣ ಜಕಣರ ನೆಚ್ಚಿನ ಬೀಡೆ ಕೃಷ್ಣ ಶರಾವತಿ ತುಂಗ ಕಾವೇರಿಯವರ ರಂಗ ಚೈತನ್ಯ ಪರಮಹಂಸ ವಿವೇಕರ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते ಸರ್ವ ಜನಾಂಗದ ಶಾಂತಿಯ ತೋಟ ರಸಿಕರ ಕಂಗಳ ಸೆಳೆಯುವ ನೋಟ ಹಿಂದೂ ಕ್ರೈಸ್ತ ಮುಸಲ್ಮಾನ ಪಾರಸಿಕ ಜೈನರು ಉದ್ಯಾನ ಜನಗಣ ಹೋಲುವ ದೊರೆಗಳ ಧಾಮ ಗಾಯಕ ವೈಣಿಕರ ರಾಮ ಕನ್ನಡ ನುಡಿ ಕುಣಿದಾಡುವ ಗೇಹ ಕನ್ನಡ ತಾಯಿಯ ಮಕ್ಕಳ ದೇಹ ಭಾರತ ಜನನಿಯ ತನುಜಾತೆ जय हे कर्नाटक माते जय भारत जननीय तनुजाते जय हे कर्नाटक माते जय सुंदर नदिवनಗಳ ನಾಡೆ जय हे रस ಋಷಿಗಳ ಬೀಡೆ जय भारत जननीय तनुजाते जय हे कर्नाटक माते जय हे कर्नाटक माते जय हे कर्नाटक माते
स्वामी Honorable Minister for Law, Parliamentary Affairs and Legislation, and Minor Irrigation, Government of Karnataka, and Pro-Chancellor of the University, B.V. NAGARATHNA, Judge, Supreme Court of India, New Delhi, esteemed Professor P. Ishwar Bhatt, former Vice Chancellor, Karnataka State Law University, esteemed syndicate members, esteemed academic council members, statutory officers of the university, esteemed judicial officers, esteemed advocates, principals of Karnataka State Law University, it is a great privilege for me to extend a very warm welcome to you all on this momentous occasion of 4th Foundation Day lecture. Karnataka State Law University was established in the year 2009 with the motto Indian Roots and Global Heights for providing quality legal education. The year 2019 was a year of decennial celebration. The university, in its journey towards excellence, completed 10 years of fruitful and vibrant existence. And to mark this, the Foundation Day lecture has been initiated as a part of decennial celebrations. And today is the 4th Foundation Day lecture. On this occasion, it is a great privilege to have Shri J.C. Madhuswamy, Honorable Minister for Law, Parliamentary Affairs and Legislation, and Minor Irrigation and Pro-Chancellor of the University to preside over the function. We are highly honored by your presence, sir. On behalf of University, I extend a cordial welcome to esteemed Shri J.C. Madhuswamy. It is a proud moment and a great honor, Judge, Supreme Court of India, to deliver the 4th Foundation Day lecture on the topic, the future of legal education and its impact on justice delivery system in India. I extend a warm and a hearty welcome to NAGARATHNA, Judge, Supreme Court of India. Esteemed Professor P. Ishwar Bhatt, former Vice Chancellor, Karnataka State Law University, a renowned scholar and eminent academician, is gracing the occasion. On behalf of all of us present here, I extend a cordial welcome to esteemed Professor P. Ishwar Bhatt, sir. A hearty welcome to esteemed Shri Venkatesh Nayak, Principal Secretary, Law Department, esteemed syndicate members, Shri Srinivas Babu, Shri N. Basavaraju, Shri Mahesh Wadiyar, they all have been a pillar of strength and support for the university. And I also extend a very warm welcome to all our academic council members. A cordial welcome to our statutory officers, Shri Mohammad Zubair, Registrar of the University, Professor G.B. Patil, Registrar Evaluation, Professor C.S. Patil, former Dean and Judge, High Court of Karnataka, Adiga, PDJ, Dharwad Court. A cordial welcome to all the esteemed judicial officers gracing the occasion, and a very warm welcome to all the esteemed advocates of High Court and local courts. And it is a moment of great joy for me to welcome all the invitees, principals and faculty from affiliated law colleges, members from media, teaching and non-teaching staff, and dear students. Once again, a warm welcome to all.
Welcome to you to the function. Welcome. I request Mr. Mohammad Zubair N, KAS, Registrar of Karnataka State Law University, to present a bouquet to Honorable Mrs. Judge as a token of respect. Thank you, State Law University, as a token of respect. Karnataka State Law University to Tangi, Assistant Professor.
Sri J.C. Swami, Pro-Chancellor of the University and Minister for Law, Justice and Parliamentary Affairs, who is presiding over the Foundation Day function. Honorable Justice B.V. NAGARATHNA, Judge Supreme Court of India, all the dignitaries, invitees and students. It gives me great pleasure in presenting before you the biodata of Honorable Srimati Justice B.V. NAGARATHNA, Judge Supreme Court of India. She was born on 30th October 1962 to Srimati Padma and Sri S. Venkatramaya, former Chief Justice of India. She did her BA Honours in History from JSS Mary College at Delhi University. She had a LLB degree from Campus Law Center in 1987 from Delhi University. She commenced practice in law in 1987 in KSLU and Company and started independent practice in July 1994. Practice in a variety of fields such as constitutional law, administrative law, service law, commercial law and family law. She also represented Karnataka State Legal Service Authority and High Court Legal Service Committee in the High Court of Karnataka. Karnataka Examination Authority, Insurance Company also. Appointed on 18 Bangalore, Chairperson Juvenile Justice Committee, Chairperson Committee overseeing implementation of POCSO Act, contributor to the book Codes of India, released in 2021, elected as a Judge of the Supreme Court of India on 31st August 2021. A future of legal education she had written. These are products of some independent thoughts. Some of the radical ideas can be found. J.C. Swami. He was a member of Legislative Assembly, elected from he is well known to whole of Karnataka as a very good parliamentarian, debater, and a person with a very good knowledge of law and insight about the policies and development. Of Foundation Day lecture is to enable that kind of interaction by very eminent persons so that the university can progress with such a knowledge generation as well as the knowledge dissemination. These types of facilities, whether it's an endowment, Foundation Day or some other thing, these provide an opportunity for a generation of new knowledge. This is actually converting a property into knowledge. That's the idea with which the syndicate had decided. Syndicate had decided in 2019 to organize a number of programs relating to decennial celebration. At a time, different parts of Karnataka, lectures were delivered by very eminent persons, Supreme Court judges and eminent legal academicians. And that actually was the method to which we could bring out quality articles and quality publications and of course a generation of new knowledge. That was the result out of it. Then we initiated a non-state justice system research projects. 10, yes sir, as many as 11 research projects were assigned to various principal investigators, and they, after conducting the research, they produced the research reports, and we have compiled it. And yes, Professor Chandra Reddy Patil and myself, we have edited that work. Because of the interaction with the KALSA, there's Karnataka State Legal Service Authority. They initiated that idea, and a handbook on para-legal volunteers. When we thought that a certificate course should be launched, we thought it fit that this kind of book could be brought out. and this is also a product of research and collective effort on the part of the faculty was responsible for this. Then during the last 4 years, we have laid emphasis on research. There are two research centers. There is a center for water studies, then a center for constitutional studies, and there is also Vijnaneshwara chair. Vijnaneshwara chair is headed by Honorable Justice Shivraj Patil. Under his guidance, of course, with the cooperation of very eminent scholars from various parts of Karnataka, we could hold one national webinar, and a number of research articles based on that kind of program could be brought out in the form of book. That's also going to be released. Foundation Day is a day where we are not only celebrating the happiness of the birth of the institution, what was its purpose, how far we have attained that purpose, and what shall be its future, and how we can contribute to the success. About all those things, we have to go for introspection. That's why I am speaking about these types of developments that have taken place during the last 4 years. Yes, about research water law. There we have involved in research about traditional methods of water harvesting and the issues of groundwater or issues relating to interstate water dispute, etc. And the product of that research center is to have one book on emerging trends in water law. That book is also going to be released today. This is a kind of achievement because during the COVID, for a period of 2 years, we could not make much progress. There was some obstruction, but still it was a challenging period. And during that time, our faculties and faculties in various law colleges could respond to the situation by equipping themselves with the idea of this online lectures and online dissemination of knowledge. That was a big development. Technologically, the legal academia could become strong because of this fact. Then Karnataka State Law University has stood for academic discipline throughout. And during the last 1 year, we had various challenges. Of course, during the period of COVID, when the students sought some remedy that there should be some method of obviating from the difficulty of examination, the Honorable High Court of Karnataka also provided some remedy. But when post-COVID, when everything was normal and all universities were conducting examination, unjustifiably, there was insistence from the unguided section of the students that without examination, there shall be award of a degree, there shall be a promotion, etc., for which we were not prepared at all. Bar Council had clearly provided that only on the basis of examination at the end of the semester that the students will be entitled to degree. And here, of course, the support that is given by our Honorable Law Minister or Pro Chancellor is something great. I am acknowledging his valuable support because by engaging senior lawyers, by vacating those stays, and of course, up to Supreme Court the matter went, but we ultimately conducted examination successfully, and the students are now free from any of the fears about non-recognition of their degree. There is no such fear at all. And all this because of the insistence on academic discipline. Even in the legislature, the Legislative Assembly, Honorable Law Minister defended that Pariksha ilde padavi illa. Pariksha madlebekaguತ್ತದೆ. That's how we should go ahead. And of course, this is how we are. Yes, KSLU is taking legal education so seriously, and concerning all aspects. During the last 4 years, yes, infrastructural development also took place. As many as 5 buildings were constructed. There's a teachers' quarters, then a boys' hostel, then 3 quarters for 3 officers, Of course, I insisted that some case pending before the High Court could be resolved, and ultimately it was resolved, and the university got entitlement to 8 acres of land, clear title, and we could get the construction of the compound wall also, and include earlier the students were staying in there could be such efforts of invoking the help of the central government, etc. Now, of course, these are the developments that we could witness. It's only because of cooperation by all that insofar as Karnataka is concerned, there is a need to have certain regional centers. We have realized that for evaluation of about 2 lakh scripts, we are doing it in a digitalized evaluation system, which are conducted in 6 centers simultaneously, and we find some difficulties to have access to some of the accommodations or physical facilities, etc. We are depending upon the private affiliated college. Instead of that, suppose some research, some centers could be established, or some institutions could be established, as that of KSLU Law School. Honors degree course can be conducted there also. Further, we have as many as 68 sanctioned faculty strength as per our government sanction order, and it is essential that we have to make a recruitment. Of course, we took a lot of pain, or we put efforts to recruit, and of course, because of COVID, there were some difficulties. Then there was some other technical difficulties, because of which the recruitment process could not take place. But it is essential that it is to be done, and even relating to non-teaching staff also, there is a need for going for a recruitment. Yes, under the guidance of Hon'ble Law Minister, who is our Pro-Chancellor, and with the cooperation of syndicate members and all, perhaps the new Vice Chancellor will be taking all such steps in this regard. Yes, all the support that you had extended to Vice Chancellor up to this time may be extended to the subsequent Vice Chancellors also, so that future of KSLU shall be strong, and there shall be flourishing of legal education in Karnataka, so that the population in Karnataka shall be legally literate, and they shall be adequately empowered, and legal education should be culturally conscious and socially relevant and globally competitive. All these objectives shall be satisfied. With this, let me conclude. Thank you very much.
It is an honor to have Honorable Mrs. Justice V.D. NAGARATHNA, Judge, Supreme Court of India, New Delhi. May I request ma'am to kindly address us on the future of legal education and its impact on the justice delivery system in India. Please ma'am.
J.C. Madhuswamy, Minister for Law, Parliamentary Affairs and Legislation and Minor Education, Government of Karnataka, and more relevantly today as Pro-Chancellor of the Karnataka State Law University, Hon'ble, Honorable Justice E.S. Indresh, and other honorable judges I am addressing in absentia. Sri Venkatesh Nayak, Law Secretary, Government of Karnataka, learned Principal District Judge Sri Adiga, and learned judges of the Dharwad District Judiciary. I am in the cusp of retiring and an incoming Vice Chancellor. So therefore, Professor P. Ishwar Bhatt, Vice Chancellor, Karnataka State Law University, and Professor Dr. Ratna R. Bharmagaudar, Dean and in charge Vice Chancellor of the University, Sri Mohammad Zubair N., Registrar, Professor G.B. Patil, Registrar Evaluation, Professor C.S. Patil, Professor of Law, and learned faculty of the universities, distinguished invitees, learned members of the bar, dear students of law, members of the press and electronic media, ladies and gentlemen. I am very happy to be here this morning. In fact, I came yesterday, and to reconnect myself with both Dharwad and Belgaum districts. Why Dharwad? Because out of my 13 and a half years as a judge in the High Court, I came more number of times to Dharwad than to Kalburgi. In fact, 11 times. I can recollect every month which I came from right from 2008 to 2019, but I don't want to waste time doing that. So 11 times I came to Dharwad, and therefore my connection to Dharwad. As far as Belgaum is concerned, it is because of my father, Sri S. Venkatramaya. First year of law he studied in ILS Pune, but I never asked him why he shifted to RL Law College, Belgaum for the second year. Anyway, he stood first in the college. That was the first class for the college. He was appointed a fellow and as usual the new teachers are given the most difficult subjects. He was asked to teach Roman law, and therefore he started his career as a law teacher in RL Law College. And thereafterwards, when he began his practice, he continued his teaching in BMS Law College and became its principal. And after retirement, he taught for 5 years in National Law School of India. And therefore, I am proud to be a teacher's daughter, and that too a law teacher's daughter. And hence, my subject for today is also on the future of legal education in India and its impact on the justice delivery system. At the outset, I deem it an honor and privilege for having been invited by the Karnataka State Law University, Hon'ble, and by Professor P. Ishwar Bhatt, particularly whom I have known for over 25 years, to deliver the 4th Foundation Day lecture this morning. The earlier lectures have been delivered by very eminent personalities in the legal field, as just now stated. Hence, I deem it an honor and privilege for having been invited today. The Karnataka State Law University was established very recently, in fact only in 2009, and it has been committed towards increasing access to quality legal education. I am delighted to note that by December 2021, the university has over 100 colleges which are affiliated to it. I am particularly impressed by the diverse nature of the LLM courses offered by the KSLU, including specialization in constitutional and commercial law. As a part of the university's ongoing commitment towards academic program, it has, apart from conventional academic curriculum, established 2 research centers. Therefore, on the occasion of the Foundation Day of these universities, I congratulate all the stakeholders who have been instrumental in seeing this university grow from strength to strength. Now, coming to my topic, I would like to begin by explaining the choice of my topic. In my view, legal education through law schools and law colleges are the bedrock whose quality and solidity determine the stability and functional utility of the superstructure, namely the law students, who may thereafter become law teachers, practicing advocates, corporate lawyers, and members of the judiciary. The character of the law school or college determines the character of the bar and the bench. As it is from the law schools and colleges that lawyers and judges emerge. Therefore, legal education should aim at promoting justice rather than resolving disputes. I shall now attempt to discuss the same. In stating that legal education must bridge the gap between law and justice, what I mean is that law must be understood after imbibing social realities and segments. Lord Halsbury has said that law is not an exact science. In my opinion, law deals with the everyday concerns of ordinary citizens, the common man. The concerns of ordinary citizens cannot be analyzed in a mechanical or a mathematical precision or that of a chemist. Law is not an exact science. That is where the role of the advocate comes to picture. And from where do the advocates emerge? From the law schools. In the lap of liberalization and globalization which India has embraced since 1990s, legal education is no longer a subject that covers the scope of law as such. It extends to social, political, historical and economic areas. It is important that law schools should curate and administer a socially relevant legal education. Justice Holmes, in his treatise on the common law, stated, and I quote, "The law is always approaching and never reaching consistency. It is forever adopting new principles from life at one end, and it always retains old ones from history at the other, which have not yet been absorbed or sloughed off. It is therefore to be understood that law as it stands at any point is a reflection of the past as well as an insight into the future, and should therefore be studied and understood as such." We all know that is the Hayden's mischief rule principle in interpretation of statutes. The vision of legal education should be to provide such education which is essential to the realization of values enshrined in the Constitution of India. That is to say, the legal education must aim at preparing legal professionals who are capable of taking up effective leadership roles, not only as advocates or academics, but as statesmen, policy makers, judges. It is my belief that a student of law is required to be given a direction in all areas of conflict inherent in a complex society and economy as ours. Only then we will be able to recognize and understand the socio-legal challenges of society and be able to seek resolution through the method of social engineering. Closely linked with the need for socially relevant legal education is the idea of providing legal education which is a proportionate admixture of substantive education along with practical skills and experience. This brings me to the next priority of legal education, that is clinical education and continuing legal education. I have always believed that the study of law cannot be in a vacuum, just as we cannot give a judgment in a vacuum. We always pass a judgment or an order on the facts. And always, as a judge, I insisted that the lawyer opens his case on facts, by reciting the facts. It ought not to be a study divorced of practical scholarship, which is only by abstract theory. The gap that has been created between legal education and practical training needs to be reduced. This is by introducing clinical legal education, that is experimental learning or learning by doing. Justice Oliver Wendell Holmes said, and I quote, "The life of the law has not been logic, it has been experience. Therefore, learning the law from practitioners who have applied the same in practice would be more effective." At one point of time, law colleges used to invite legal practitioners, senior advocates to teach. They may not have had an LLM degree, but they would be invited to teach in the law colleges. Of course, those days it was a 3-year law program. 7 a.m. the colleges would start and up to 10, or it would be in the evening at 6 p.m. and up to 9:30 or 10. And advocates used to go and teach in the law colleges, particularly on procedural side, CPC, CRPC, Evidence Act. But that is not happening as such, because they say that you need an LLM degree to teach. But I think you must invite advocates to teach, those who are good, having an academic bent of mind, to take classes at least as guest lecturers. Also, the introduction of legal aid programs is important. When the law students interact with the persons who come with problems or the clients in the legal aid clinics of the law colleges, they would interact with people who have problems, irrespective of whether they share their own racial, ethnic, religious or other backgrounds. This window into the lives of marginalized and poor communities will give the law students the ability to formulate and promote more inclusive policies in their own practice as lawyers, as well as in their role as judges or legislators if they so become. Then, in my view, all narrow-mindedness and that what we call in Kannada, Kupa Manduka, that mentality will disappear. It is necessary that in the law colleges itself, we have this kind of exposure of our students to every segment of society, particularly the marginalized and the weaker sections of society, so that they understand as law students what is there for them in the profession. Whether they may become legislators, they may become bureaucrats in future, they may become academicians, or they may become advocates. So therefore, this kind of an introduction to the various segments of society by the law students is very essential, according to me. With a view to increase equitable access to justice, the Bar Council of India has enacted the Bar Council of India Rules of Legal Education 2008, and it has made it mandatory for every university in India to have legal services clinic. But these clinics must have a meaningful interaction with the clients and a functional one. But there are reasons as to why these clinics are not functioning, though they are there formally. One is because of lack of full-time specialized staff. And these clinics function as per the academic calendar of the university or the college, and they won't function during exam times, they won't function during vacation times. Then where should the ordinary man who wants advice go? Therefore, it should be a full-time activity of the clinics, and there needs to be more dialogue between the practice and the academia. For the success of these clinics, you must involve more of advocates or law practitioners to come and guide our students, to guide the persons who come to the law clinics for advice. Then next we go to the curriculum as such. As I already said, before venturing out to understand and apply the law, one has to understand life as it is. It is only based on an understanding of the social realities that the law can be understood and applied in the right spirit. It is in that context that I emphasize that the gap between the legal academia, legal profession and dispensation of justice needs to be breached. According to me, the topic is legal education and its impact on dispensation of justice. So don't restrict legal education only to giving of a degree to students, full stop. No, it is a continuous process, and I'll explain how it is. First, the legal curriculum must incorporate, as I said, clinical legal education, practitioners' workshops, legal writing and alternative dispute resolution into a national course module. The course module must make it mandatory that senior legal practitioners, that is advocates with expertise in particular areas, especially in procedural law, teach a certain number of classes. But today the legal education sector, the bar, the bench, the corporate legal sector and law firms continue to function in silos of isolated splendor when the need is for the opposite, that is a close, continuous, coordinated alignment with legal education. In fact, you see the topmost academia from Harvard, they're all very good academics. They work as law clerks to the Supreme Court judges in America. Some of the Supreme Court judges in America are academics. They not even practice law. So therefore, we must bridge this gap between academia and law practitioners so that the law students are exposed to law practitioners, and law practitioners or advocates also are reminded of continuous legal education. It's a two-way traffic. The other side of the coin is for expertise in law professors to be invited by courts of law or to be engaged by courts of law to assist the judiciary in matters which require the judges to theorize or conceptualize after employing empirical, interdisciplinary or comparative approaches. There have been several noteworthy instances where academics have assisted the justice delivery system. We cannot also ignore the academics, particularly in the legal field. For example, the role of late Shamnath Bashir in the matter concerning Novartis India, or the role of Dr. Professor V.S. Mani, the founder, Vice Chancellor of Gujarat National Law University, as a member of the team that represented India before the ICJ in the year 1999 aerial incident case between India and Pakistan, are noteworthy to remember. Law schools must therefore build a collaboration with lawyers and law firms. They could be by organizing lectures by members of the bar and by judges, training sessions being conducted by partners or senior associates in law firm, collaborative research workshop. It is through such partnership between various stakeholders in the legal fraternity that law schools can be transformed into something much greater than mere fertile grounds of generating law graduates. Second is the need for sponsorship for interdisciplinary legal research by the Bar Council of India, University Grants Commission, and such other institutions concerning law as a social science. Such interdisciplinary research has been undertaken through projects such as the Death Penalty India project by National Law University Delhi in association with National Legal Services Authority, then the Access to Justice India project undertaken by Salgaonkar Law College, Goa in association with United Nations Development Programme. When students are made part of such projects, they can develop the skills of critical reasoning, close reading and clear writing, along with the ability to carry out good quality research bearing in mind social responsibilities. We have here today Mr. Srinivas Babu, who is not only as a member of the syndicate of this university but also a member of the Bar Council. He was a former chairman, and hence I am happy that you are here, sir. And I would like to say something on the role of the Bar Council of India in revamping legal education. Advocates Act 1961 is a landmark legislation enacted to regulate and manage the legal profession and legal education in our country. The BCI has been entrusted the role of promoting legal education and laying down standards and practice in consultation with various universities. As I said, the Bar Council of India has enacted the Bar Council of India rules, Bar Council rules, education rules of 2008. A study of these rules would reveal that the aim of the BCI is to make the study of law practical, so as to enable students to find answers to the legal conflicts that they encounter in a fast-changing and dynamic society as ours in India, encountering several problems. Therefore, the emphasis is on practical and not merely lectures or classroom attendance as such. But the Bar Council has a statutory role. It must ensure that this regulatory role is wielded to ensure that the students graduating from any law school or law college in the country, and not just the national law schools, would be trained to uphold the high and noble traditions of the bar and contribute in a significant way in the dispensation of affordable and prompt justice. What are the ways and means of achieving the aims and objects of the Bar Council in the context of legal education? The first step towards achieving such an aim is to check the mushrooming of ill-equipped law colleges with skeleton libraries and lacking well-trained faculty. The emergence of the national law universities in India and the introduction of the 5-year integrated law program in the 1980s was certainly significant, but that is not sufficient. The long-term success of NLSUs has also been assessed to be good. However, the BCI must act as a custodian of the legal education standards being maintained to ensure that every institution gives quality education. Otherwise, the Bar Council must take a decision to simply close those institutions which are not giving quality legal education. In my view, the BCI should use the power vested in it to prescribe standards which are not limited to the minimal prescription as to the curriculum or attendance requirements. They should include within their ambit certain guidelines as to timely internship, participation in moot court competition, requirement to undertake research and writing activities. And when I say research and writing, it need not be only writing in English. Of course, English is the language of the High Courts and the Supreme Court, even as per the Constitution. But legal writing need not be limited to English only. Good legal writing in Kannada language also must be emphasized and encouraged. The BCI may prescribe certain standards in the following areas. I won't read everything, it's a long speech of 50 pages, but I therefore don't want to bore you. I'll make it as short as possible and say that what are the areas where you can improve? Teaching models and techniques, examination system, and regulation to bridge the gap or differences amongst law schools and law colleges. Let me talk about examination system because our students are here. Currently in most law schools, the malady of covering a part of the prescribed syllabus and fallacy of memorizing selected questions and answers rules the roost. That is so even now. The sad reality is that the grade card of students is a reflection of their ability to mug up a few topics instead of learning or analyzing the law and practical attributes. Case study based papers for certain subjects may be more effective in driving home not only the first principles of law but their nuances also. The increasing level of differences amongst the level of educational institution has created a significant divide between the so-called elite institutions and the rest of the institutions. The culture and teaching and learning process of these institutions differ widely, and as a result, students' learning outcomes also differ. It is therefore the need of the hour to bring about uniformity in the quality of education across law schools and law colleges in the country, and so that they have functionality of the library, access to learning resources, ability of institution to collaborate with law practitioners, law firms, PSUs to secure internship and job opportunities for the students, and contribution of the institution towards legal research. Also, legal language and legal writing must be given an impetus in non-law schools. In law schools, they do projects, they have to write, but in non-law schools and in colleges, that is not there. Uniformity in the quality of education across law schools and colleges needs to be the aim in order to ensure that the legal educational arena does not become a sea of mediocrity with a few islands of excellence. Thus, on the one hand, there is need to restructure the LLB curriculum by having a multi-dimensional need-based training program to be designed and mounted according to the needs of professionals. On the other hand, there is need for training of advocates on their joining of the profession to enhance their capacities in problem solving by acquiring skills, attitudes and ethics, by analyzing the fact situation of the cases and that they handle, and to apply legal knowledge professionally and competently. My simple reminder to the legal practitioners is, don't forget education after the 3-year or the 5-year law courses that you have attended and got the degree. Legal education doesn't stop. at that. Even today, on the bench of the Supreme Court, I am not only a judge, but I am a student of law. I am learning every day. Every day I learnt in the High Court. And who are my teachers? My teachers were the advocates who came and argued before me. And I learned from them. And I was able to write. If at all I wrote good judgments, the credit must go to the advocates who came and argued. And in the Supreme Court also, I must say that my learning has not stopped. In fact, it has become more. It has become greater and more intense and deeper. Professor N.R. Mathamenon, in his article Continuing Legal Education and the Role of Bar Councils and Bar Association, has observed that perhaps no other profession felt the need for education and training on a continuing basis more than those involved in the delivery of legal services, recognizing that corporate legal practice around negotiation, arbitration, and transactions management are vastly different from litigation practice in terms of skills, attitudes, and ethics. He stated that the foundational training for lawyers, that is the LLB, though being revised, is unlikely to fulfill the nature of evolving demands for specialized legal services from different sectors of the economy and from an increasingly aware civil society. Therefore, continuing legal education becomes imperative for all sections of legal practitioners. And what is best is self-education. Self-education is the best for lawyers. Of course, they learn from case to case. When they argue, they learn from the courts. They learn through their own thinking. They learn from the client. We all learn from the client also. And how to put across the arguments where the client would give you the ideas about his case because he knows best of the problem he is facing and the facts he has faced. But you will mold it in the legal language and put it to the bench. My suggestion with regard to revamping of the curriculum is first to have a clear distinction between a 3-year law course and a 5-year law course. Of course, these are all my humble thoughts, and it will take a long time for all these to be first accepted as such because they are quite radical also. Next, in order to enable law schools and law colleges to incorporate the best practices of legal education into the curriculum, it may be necessary to extend the course duration of the BA, BBA, BCom, LLB integrated program from 5 years to 6 years. The last year of the 6-year program may be dedicated for internships and practical training, which is specific to the future career aspirations of each student. Now it is a 5-year law course, and in the 5th year you are doing that. Consequently, what is you are missing out is, you are missing out on certain substantive law subjects and at the same time trying to cramp the practical aspects. Therefore, you make it 6 years. We all studied 3 years BA, BCom or BSc and 3 years of law. So therefore, we all had 6 years of university education, and I don't think we lost anything in life by doing 6 years of law. Therefore, the really interested, serious and persons who have thought of about the law curriculum will go for the 6-year law course. In America, it is 4 years of pre-medical and 4 years of medical. If a person wants to be a doctor, he has to study for 8 years. So why not we make the law course 6 years so that the really interested will go. I will tell you how. Apart from restructuring the curriculum of the 5-year law course to a 6 years one, there must be complete practical training given to the law students in the 6th year. The practical training must be imparted to enhance their skills as an advocate and therefore necessary skills of advocacy, professional ethics, and such aspects must be taught in the first part of the 6 years. All the advocates, legal practitioners who are good, and you have now not only from Bangalore, you can call them from close by, Dharwad bench, the practitioners to come and teach. In the next part, skills to be acquired in order to join the judiciary must be imparted. Now you know, because of the Supreme Court judgment, any student out of law college can straight away come and take the exam and become a civil judge or a munsif. The 3-year practice is not necessary. So give them an idea of what it is to be a judge, preparation to be a judge, and judicial ethics. Then the next segment must be to concentrate on legal drafting, legal writing and draftsmanship, so that people who want to join as draftsmen in the legislature department will have that opportunity. Bureaucrats also will have, future bureaucrats will have an idea. I am sure our Minister of Law will also be knowing that how difficult it is to get the exact words from Kannada to English and English to Kannada. The exact text, because that is what you have to project ultimately to the bench when there is a validity question which raises. We always say get the Kannada version if we are not happy with the English version, because initially it is made in Kannada and then translated. So we see both in, at least I used to ask for both. Then the next is, so therefore this is for future administrators and bureaucrats. And the other is to give basic skills to those who want to go in the academia, those who want to be law teachers, law professors. It's not just getting an LLM to become a law professor or a law teacher. Teaching of law is more difficult sometimes than arguing in a court. My senior, Mr. G.V. Shantaraju, he was a teacher in Hon'ble Law College and then he was a principal there. Many of my senior colleagues in KSLU and company in the evenings they used to go and teach. And my senior, Mr. G.V. Shantaraju, used to say, it's not easy stating or speaking in the court, as it has become greater and more intense and deeper. Professor N.R. Mathamenon, in his article Continuing Legal Education and the Role of Bar Councils and Bar Association, has observed that perhaps no other profession felt the need for education and training on a continuing basis more than those involved in the delivery of legal services, recognizing that corporate legal practice around negotiation, arbitration, and transactions management are vastly different from litigation practice in terms of skills, attitudes, and ethics. He stated that the foundational training for lawyers, that is the LLB, though being revised, is unlikely to fulfill the nature of evolving demands for specialized legal services from different sectors of the economy and from an increasingly aware civil society. Therefore, continuing legal education becomes imperative for all sections of legal practitioners. And what is best is self-education. Self-education is the best for lawyers. Of course, they learn from case to case. When they argue, they learn from the courts. They learn through their own thinking. They learn from the client. We all learn from the client also. And how to put across the arguments where the client would give you the ideas about his case, because he knows best of the problem he is facing and the facts he has faced. But you will mold it in the legal language and put it to the bench. My suggestion with regard to revamping of the curricular is first to have a clear distinction between a 3-year law course and a 5-year law course. Of course, these are all my humble thoughts, and it will take a long time for all these to be first accepted as such, because they are quite radical also. Next, in order to enable law schools and law colleges to incorporate the best practices of legal education into the curriculum, it may be necessary to extend the course duration of the BA, BBA, BCom, LLB integrated program from 5 years to 6 years. The last year of the 6-year program may be dedicated for internships and practical training, which is specific to the future career aspirations of each student. Now it is a 5-year law course, and in the 5th year you are doing that. Consequently, what is you are missing out is, you are missing out on certain substantive law subjects and at the same time trying to cramp the practical aspects. Therefore, you make it 6 years. We all studied 3 years BA, BCom or BSc and 3 years of law. So therefore, we all had 6 years of university education, and I don't think we lost anything in life by doing 6 years of law. Therefore, the really interested, serious and persons who have thought of about the law curriculum will go for the 6-year law course. In America, it is 4 years of pre-medical and 4 years of medical. If a person wants to be a doctor, he has to study for 8 years. So why not we make the law course 6 years so that the really interested will go. I will tell you how. Apart from restructuring the curriculum of the 5-year law course to a 6 years one, there must be complete practical training given to the law students in the 6th year. The practical training must be imparted to enhance their skills as an advocate, and therefore necessary skills of advocacy, professional ethics, and such aspects must be taught in the first part of the 6 years. All the advocates, legal practitioners who are good, and you have now not only from Bangalore, you can call them from close by, Dharwad bench, the practitioners to come and teach. In the next part, skills to be acquired in order to join the judiciary must be imparted. Now you know, because of the Supreme Court judgment, any student out of law college can straight away come and take the exam and become a civil judge or a munsif. The 3-year practice is not necessary. So give them an idea of what it is to be a judge, preparation to be a judge, and judicial ethics. Then the next segment must be to concentrate on legal drafting, legal writing, and draftsmanship, so that people who want to join as draftsmen in the legislature department will have that opportunity. Bureaucrats also will have, future bureaucrats will have an idea. I am sure our Minister of Law will also be knowing that how difficult it is to get the exact words from Kannada to English and English to Kannada. The exact text, because that is what you have to project ultimately to the bench when there is a validity question which raises. We always say get the Kannada version if we are not happy with the English version, because initially it is made in Kannada and then translated. So we see both in, at least I used to ask for both. Then the next is, so therefore this is for future administrators and bureaucrats. And the other is to give basic skills to those who want to go in the academia, those who want to be law teachers, law professors. It's not just getting an LLM to become a law professor or a law teacher. Teaching of law is more difficult sometimes than arguing in a court. My senior, Mr. G.V. Shantaraju, he was a teacher in Hon'ble Law College, and then he was a principal there. Many of my senior colleagues in KSLU company in the evenings, they used to go and teach. And my senior, Mr. G.V. Shantaraju, used to say, it's not easy stating or speaking in the court, because you don't know what time, a judge will ask questions only concerning a case, but a student can ask a question even outside the subject as such, but related to the subject. So therefore, to be an academic or to join the academia, what it entails, our law students must know, and not just going in from LLB to LLM and then teaching, etc. So this is what, as a result of, then what the other thing I have said is that there must be a division, I said, of the 3-year law course and 6-year law course. As a result of what they wish to pursue in a career of law. The segregation will filter those students who are interested in acquiring a law degree for reasons which are not for the legal arena. Many persons who are working seek a law degree because they may get a monetary incentive in their service. Such people also attend the 3-year law course. And their curriculum, students who have joined in the 5-year or 6 years to be would require. The Bar Council of India may consider the aforesaid suggestions, which would give an impetus to the students to be conscious of lawyers for achieving a prompt justice delivery system. This would have an impact on the future socio-economic and political developments in the country. Now we all know that the new education policy 2020 has come. There is one striking aspect of that NEP, and that is the non-implementation of the standing demand to place legal education under a professional body called National Council for Legal Education, NCLE, wherein all stakeholders such as the Bar Council, law teachers, governments, students, etc. would have representation. While it is clarified by NEP 2020 that the proposed National Council for Higher Education would not govern legal education and medical education, no proposal has been accepted to NCHE. This aspect of NEP places an enhanced degree of responsibility on the Bar Council of India, who should now enhance its role and responsibility as an academic regulator for law schools and colleges, bearing in mind the changing face of the legal education and newer skills to meet the demands of a globalized economy. Then the next topic, the future of legal education in India. The need for promoting excellence in legal education should be predicated with a view to respond to the following parameters. I will not read it, but I will just cite it. First is globalization and its impact on legal education. The second facet of the future of legal education in India is academic freedom in legal education. By academic freedom, I mean that the law universities need to evolve and become grounds where knowledge is created and developed in light of changed needs of the society. Law is a dynamic discipline, and it is necessary that the laws and the legal transformation in the country. Thus, the role of law schools and law colleges in India is paramount in forging these changing understandings by incorporating legal research, leading to suggestions being made to the Parliament or state legislature for bringing about new laws or reforms in the existing law. Then therefore, what is the way forward? Some of the good lawyers and teachers and professionals, expanding the presence of good caliber law teachers who can motivate the students and impart good education, legal education, including clinical legal education, motivating law students to choose various career paths within the legal profession or to opt for legal academia, and sustaining good legal talent within India, which includes persuading lawyers who are practicing or working abroad to return to India to pursue similar work. Unless we have a critical mass of good law teachers, it will be difficult to see widespread improvement at the entry level of the bar. Now I say entry level of the bar. Now the bar. Lawyers represent the foundation of our society, which is based on rule of law, and the standard of legal education received by them would greatly determine their individual development and ability to face new challenges in the career. The multidisciplinary and multifaceted aspect of legal education, if nourished properly, can evolve the human resources of our country, resolve legal disputes speedily, strengthen good governance in India, and play an integral part in our nation's development by aiding the system of dispensation of justice more efficiently. Let us remember that the people who were trained in the law played an important role in India's freedom struggle and later contributed to the drafting of India's constitution, one of the finest in the world, as well as made the weightiest contribution to the governance process in the early years of nation building. While different disciplines of study equip people with different kinds of expertise that assist governance, law teachers and lawyers should understand the need for the protection of the rule of law and the assurance of access to justice and fairness, and mold the content of legal education accordingly. In Sanjeev Datta versus Ministry of Information and Broadcasting, the Supreme Court observed, and I quote, "The legal profession is different from other professions in that what lawyers do affects not only an individual but the administration of justice, which is the foundation of the civilized society." At this juncture, I must also say that meritorious young lawyers face difficulties in the initial years of their profession, which has been highlighted by Justice Bhanumati in the judgment S. Sheshachalam versus Bar Council of Tamil Nadu and she states, and I quote, "New entrants to the profession in the initial stages of their profession suffer with a meager stipend which young lawyers may receive in their initial years. Coupled with the absence of a legislation concerning this, they struggle to manage their food, lodging, transportation and other needs." Especially lawyers who come from the rural areas and want to practice in the, not only in the taluka headquarters or district headquarters, they face a lot of problem. And therefore, in that context, I urge and appeal to the senior members of the legal profession to nurture the junior members of the profession and mentor them. Learning from seniors and peers is an important aspect of legal education. That brings me to the next segment of my lecture, which is on the legal profession in India, which is the bedrock of justice delivery system. The Advocates Act 1961 was enacted to amend and to consolidate the law relating to legal practitioners and to provide for the constitution of bar councils and All India Bar. The Act has integrated the bar into a single class of legal practitioners known as advocates under Section 33 of the Act. Practice of law would include not only appearances before courts or other authorities, that is litigation, but also non-litigation work such as negotiations, conveyancing, giving of advice, etc. With technological advances, the face of the legal profession is changing in terms of both expectation of consumers of legal services as well as the dispensation of justice in courts of law. Hence, it is my view that there has to be a comprehensive law bringing under one umbrella all professions who are dealing with law, because chartered accountants and other persons also advise in law. Company secretaries, they are also dealing with law, and they must come under one umbrella, and hence the Advocates Act must be made more comprehensive so as to define what is practice of law and legal profession. It's not just in the law courts, it is wider, it is outside the law courts also, and how the same can be regulated in relation to advocates, non-litigation advocates, consultants, in-house counsel, etc. Lord Macmillan in his book on law and other ethics said, "The practice of law is more than a mere trade or business, and those who engage in it are the guardians of ideals and traditions." A lawyer who is enrolled as an advocate is an officer of the court who owes a duty to the court, to the client and to his opponent in order to ensure that justice is done in the case. Very often a conflict would arise as to whether the duty to the client is higher than the duty to the court. A lawyer's integrity is put to test, not just while he is appearing before the courts of law or authorities, but also while working in his office and meeting clients. This kind of ethics education must be given right in the law school itself and not to be learned later in the practice. An advocate is a public servant discharging a duty to the litigant public, no matter what his chosen field of practice is. He is the bulwark in the implementation of rule of law in our country. An advocate is bound by various unwritten obligations which are meant to preserve the integrity of the bar and the integrity of the legal profession. Transgression of these honorable obligations is not like making a mere mistake or negligence. It involves infringement of his moral duty and conscience. In my opinion, the contribution that an advocate makes to the development of rule of law is more important than what is commonly realized. It is the process of applying and adapting abstract law to the cases in hand that the function of an advocate comes into play. The quality of assistance that an advocate renders to the court correspondingly enhances the quality of justice as well as the judgments. It is in that context that I again quote Lord Macmillan, and he said, "Advocacy is beset with perils, but there is no other sphere where the gifts of character and uprightness are more sure of recognition and reward." The legal profession is a noble profession aimed at public service for securing justice to the litigants. The important role of lawyers and advocates in the society cannot be undermined, for they are persons on whom not only the clients or the litigant public depend for seeking justice, but more importantly, the courts look up to them for assistance in arriving at a just and fair decision or resolution of the conflict. This has been recognized by the Apex Court in the case of Indian Council of Legal Aid and Advice versus Bar Council of India. The nobility of the legal profession lies in the relentless and compassionate efforts of the legal professionals to uphold the ideals of the society. Judges, lawyers, and other legal professionals work together in tandem for the better administration of justice. The idea of justice, equality, and good conscience drives the legal professionals in their quest to reform the society. Therefore, dispensation of justice does not solely depend on the judiciary, but depends on the synergy between the bar and the bench. Advocates are entrusted with the task of presenting the best case forward, and the judiciary has to scrutinize every statement and attack of either side in an impartial manner to reach a just and sound judgment. That is how a strong bar makes a strong bench. In R. Muthukrishna's case, the Supreme Court has said that an independent bar and an independent bench form the backbone of democracy, and the bar and bench are complementary to each other, and without their active collaboration and mutual support of one another, it would be impossible to preserve the rule of law in the country. Therefore, I come back to the bar councils, Bar Council of India and Bar Council of the states, to come together to reform the system by timely interventions so as to uphold the eternal values of the legal profession and ensure that the future generation of lawyers who are all here would be a catalyst for change in the justice delivery system. The quality of justice would improve with the quality of legal education. The problems faced by the litigant public in the form of inadequate financial resources, lack of quality legal professionals, and thereby lack of quality legal services, falling ethical standards, never-ending delays in law courts, and insurmountable cost in litigation have had an adverse impact on the justice delivery system in the country. Although the policy of economic liberalization, which started in the early 90s in the context of globalization and privatization, has attracted many students to pursue a legal career and to cater to foreign investors, and despite many corporate law firms across the country, along with law schools being established in every state to train students to meet the changing demands of the economy, there seem to be many grey areas which have led to the litigant public and consumers of justice to be unhappy with the justice delivery system. Hence, in my view, major reforms have to be made right from the stage of legal education, next legal profession, and later the impact can be felt on the justice delivery system, because there would then be judicial reforms also. The time has now come to think about a robust legal education with emphasis on practical skills and professional ethics, which would create a generation of legal professionals who would provide inexpensive legal assistance to the citizens who are in need of it, and who would be resilient not only in the traditional methods of assisting the courts to arrive at a just and fair decision, but also in the alternative dispute resolution mechanism, such as through Lok Adalat, mediation, as well as arbitration. Legal education must emphasize that the legal professionals are meant to aid and assist the litigant public and those in need of legal services. It is not the other way around. Ultimately, legal services must lead to perpetuation of rule of law. The legal profession is an independent profession inasmuch as the advocates stand up to the might of the governments on behalf of the ordinary citizen while seeking justice for them. Therefore, independence of the legal profession would mean self-regulation. At the same time, we have the apex body, namely the Bar Council of India as well as the Bar Council in the states, who are regulatory bodies, and they make regulations to meet the challenges or the changes that needs to be made. The Bar Council not only prescribes standards in the curriculum, but also is a watchdog for not the law colleges alone, but also for the advocates. The expectation of the citizen in general and litigant public in particular in the legal services is very high. In every other field of activity, whether in science, in the corporate world, or in the bureaucracy, there has been a redefining of values and standards to meet the global needs as well as the national demands. In the legal field also, the need to upgrade the legal profession to the changing demands of the nation, particularly in the context of liberalization, globalization and privatization, is of utmost importance. I say so because litigants, whether from rural areas or urban areas, illiterate or educated, face similar problems from the legal field and the system. It is not only the lack of understanding of the law, but a sense of insecurity and uncertainty that is faced by a citizen in need of legal services or seeking justice that is worrying. Exorbitant costs and delay in reaching finality of the dispute is also worrisome. This aspect must be recognized by the Bar Council of India as a regulator watching over the profession, and must accordingly act in a statesman-like manner in not only ensuring ethical standards are adhered to, but the legal fraternity is fashioned into a robust body by elimination of pseudo-lawyers, persons who indulge in malpractices and other elements in the legal profession who are bringing down the standards of our noble profession. The legal fraternity is the guardian of the legal system in India, and the Bar Council, being the apex regulatory body, must discharge their duties in the best possible manner so that the body of advocates as a whole and individual advocates in particular render the best legal service possible in every nook and corner of our vast country. The Bar Council must coordinate with advocate bodies at the central, state, district and taluka level to bring about the best in enhancing professional skills so that the legal talent and acumen is made more effective in the dispensation of justice through the hierarchy of courts, through the length and breadth of the country, as the same helps in the development of the nation as a whole. The BCI must also ensure that the standard of law teachers and standard of legal profession are reinforced and maintained. Thus, a two-pronged reforms is required, one in the context of legal education and the second is in the context of the legal profession. I think I have taken a long time and I thank you for your kind attention. I would end my address by quoting the eminent jurist Sri Nani Palkiwala on legal education and continuing education. He says, lawyer's education is a process extending a whole career. It starts with the academic stage, extends through training in courts, and continues through a mix of self-education and learning from peers for long as a person is involved in legal work. The stress is on the importance of the capacity to learn, which must be developed at the earliest possible stage, that is the law school. I once again thank the Karnataka State Law University, Hon'ble, for inviting me to deliver this lecture. I thank each one of you for your kind attention.
Thank you, ma'am, for an enlightening address. Now, I request Professor Dr. Ratna R. Bharamgowda, Honorable Acting Vice Chancellor, Karnataka State Law University, to kindly felicitate Honorable Mrs. Justice B.P. NAGARATHNA, Judge, Supreme Court of India, New Delhi. I request all the syndicate members to kindly join.
Madam, 1 second. Sir. Sir. 1 second, madam.
Successive Vice Chancellor of the Karnataka State Law University have raised the bar one after the other under the great leadership of Professor Ishwar Bhatt, who is known for his scholarly writings. The Karnataka State Law University is bringing out 4 outstanding publications. It is my privilege to speak few words about the books that are about to be released by the dignitaries. As it is already made out, we have a chair, Vijnaneshwara chair, which is established at the instance of the government of Karnataka. This is the corpus provided by the government of Karnataka. This chair is operated. Honorable Justice Shivraj Patil sir, former Supreme Court judge, is the chair professor for this chair, and under the guidance of Justice Shivraj Patil and our Professor Ishwar Bhatt sir, we had a national webinar wherein scholars from different parts of India participated and contributed papers. And we requested all the scholars to subsequently revise these papers and send it to us, and the editorial board consisting of Honorable Justice Shivraj Patil sir, Professor Ishwar Bhatt and myself, we worked on it, and the book is ready to be released. There are 4 parts in this book. Part 1 deals with the generic aspects of comprehending the overall gamut of intellectual movement transcending the barriers of time in the state of Karnataka. In this part, the first article is by Professor Ishwar Bhatt, which traces the genesis of socio-legal values in Rita principles, Vedic thoughts, ancient concepts, and their influence through commentaries on books of law. The second article is contributed by Sri Veerappa Moili, who surveys major aspects of Vachana, Haridasa, Janapada literature, highlighting the morals underlying their essence. The third article is contributed by Professor Gururaj Karajigi, which surveys the pro-society values in Dasa and Vachana literature, which laid foundation for the concept of law and justice during that time. The fourth article is contributed by Professor Vijayendra Kumar, Vice Chancellor of NAGARATHNA, which explores interpretation and application of Mitakshara through a socio-legal analysis of Hindu law in modern times. Sri Sudesh V. Pai has contributed the fifth article, which goes to the roots of Hindu laws, aim at expanding happiness through ideal conduct of dharma, and questions whether transformation of Hindu law in modern times has kept that valuable link between dharma and personal law. Part 2 of the book is devoted to the great jurist the country has seen, Paramahamsa Vijnaneshwara himself, and an article written by a great scholar, Professor B.N. Sampath, is reproduced in this part. The second article in this part is contributed by that eminent professor, Professor T.V. Subbara, which identifies the basic thrust of Mitakshara as promoting dharma. The third article is again by our Professor Ishwar Bhatt sir, which brings out the philosophical foundation of property right from the perspective of Mitakshara. The fourth article is contributed by Professor Rajashekar, former Dean of Karnataka University, which discusses the Mitakshara principles on debts. The central theme of part 3 of the book is exposition of phenomenon from a feminist perspective. It starts with a discussion by Sri C. N. Ramachandra of a proposition that changes coexist with continuity in the context of Smriti and women, and even in the context of Constitution and women. The second article is by C.S. Patil, which analyzes the legal framework that was designed to address the offences against women during the time of Vijnaneshwara. The third article is contributed by Professor Gurudat Chilakunda, which is about Mitakshara from the feminist perspective with reference to Stridhana. The fourth article is by Dr. Akhila Baslali, which traces Vachana's strong arguments for treating women on par with men. Part 4 has varieties of themes focusing on specific aspects of socio-legal values. The first article is contributed by Dr. Lohit Naikar. It focuses on Basaveshwara and human rights. The second article is contributed by our former Vice Chancellor, Professor T.R. Subramanya. It is about an assessment of the application of the principles of equity by the British Indian courts while giving effect to Mitakshara and Dayabhaga. The third article is by Sri G.C. Tallur. It explores socio-legal values in Sarvagna literature, which could be categorized as part of Niti Shastra or science of moral principles. The fourth article is again by Professor P. Ishwarvat, which depicts Mitakshara's approach to polity, good governance and people's welfare. The fifth article is contributed by Sri Ramjan Darga, which discusses the concept of social justice in Basavanna's Vachanas. The final article is by Sri Anil Kumar Bommagatta, which lays a focus on interdisciplinary approach required for understanding the process of interaction between law and morality in the light of Haridasa literature. That is the book that is going to be released in the presence of this august audience. The second book is that book.
मैडम थोड़ा साइड
for research in water laws. The book is titled Emerging Trends in Water Law and Management, and the contributions to this book are by Professor P. Ishwarvat, Dr. Akhila Baslali, and the research assistant Nayashree Boske. The themes of the articles are jurisprudence of integrated approach on sharing, quality management and conservation of water, regulating and managing groundwater in Karnataka, water constitutionalism a study, Kattas of Dakshina Kannada, Udupi and Karnataka and Kasaragod of Kerala, and the elements of ecology, equity and development with justice in the Mahadayi Tribunal's decision of interstate water disputes, and interlinking of river projects in Karnataka and overview. These are the outstanding articles that go into this book. May I request the Honorable Justice to please release this book. you very much, ma'am. Thank you, sir. As we all know, there are certain justice dispensation systems which are in practice in the tribal communities, in the temples and in NGOs, and for this research proposals were invited from the academicians all over the state. 11 research proposals were submitted which were sponsored by Karnataka State Law University, and all these 11 research projects have undertaken an empirical survey of the non-state justice systems that are prevailing in the state of Karnataka. This book is in 3 parts. The first part is community-based non-state justice system, wherein the state and dispute resolution in Ambuja Jain Temple, and another scholar has worked in the area of tribal communities of Chamarajanagara and Mysore districts, and another scholar has worked about the justice dispensation system in the Nayaka tribes of Chitradurga district. Another part is about organization-based justice dispensation system, which covers the study of religion-based or spirit-based non-state justice system, wherein the study covers Daiva or Bhuta worship. Yes, sir. That is the religion-based or spirit-based non-state justice system. Different dispute resolution systems obtaining in mutts and temples are covered in this book. And may I request the Honorable Minister. Yes, please. Another book that is right now being released is an handbook of paralegal volunteers. The initiation taken at the base of Kalsa.
Sir, one second.
Non-state justice system. Yes.
Sir, one second. Madam.
State Law University to raise the bar further. Thank you very much for the effort.
Thank you, sir. Today, we also have the release of Karnataka State Law University's newsletter, Amrita Vahini, which is the testimony for all the... Nagarathnna, Judge Supreme Court of India, New Delhi, to kindly felicitate Professor Dr. P.E. Sharbat, former Vice Chancellor, Karnataka State Law University, and I request all to join.
Yes, sir. Yes, sir. Thank you.
ರತ್ನ ಅವರೇ, ಕೂತಿರುವಂಥ ಹೈಕೋರ್ಟ್ನ ನ್ಯಾಯಾಧೀಶರುಗಳೇ, ಬೇರೆ ಬೇರೆ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಾಧೀಶರೇ, ಈ ಯೂನಿವರ್ಸಿಟಿಯ ಎಲ್ಲ ಬೋಧಕ ವರ್ಗದವರೇ, ಬೋಧಕೇತರ ವರ್ಗದವರೇ, ಈ ಭಾಗದ ಸಿಂಡಿಕೇಟ್ ಸದಸ್ಯರೇ ಮತ್ತು ಅಕಾಡೆಮಿಕ್ ಕೌನ್ಸಿಲ್ ಸದಸ್ಯರೇ, ಎಲ್ಲ ಸಾರ್ವಜನಿಕ ಬಂಧುಗಳೇ, ವಿದ್ಯಾರ್ಥಿಗಳೇ, ನಾನು ಮೇಡಮ್ ನಾಗರತ್ನ ಅವರು ಸ್ವಲ್ಪ ಹೈಕೋರ್ಟ್ ಜೊತೆ ಇದ್ದಾಗ ಸದರವಾಗಿ ಮಾತಾಡ್ತಿದ್ವು. ಒಂದ್ಸಲ ನಾನು ಮಂಡ್ಯ ಜಿಲ್ಲೆನಲ್ಲಿ ಓಡಾಡ್ಕೊಂಡು ಬರ್ತಿದ್ದೆ. ಬೈಲಲ್ಲಿ ಒಂದು ಮಂಟಪ ಕಾಣ್ತು. ಯಾರಾದ್ರೂ ಇದು ಮಂಟಪ ಅಂತ ನನ್ನ ಆಫೀಸರ್ಸ್ ಕೇಳಿದೆ. ಮೇಡಮ್ ಅವ್ರು ತಂದಿದ್ದು ಸಾರ್ ಅಂದರು. ನಾನು ಹಿಡಿದೋಗಿ ನೋಡ್ಕೊಂಬಂದು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೆ, ನನಗೆ ಹೋಗಿ ಬಂದೆ ಇಲ್ಲಿ ನಿಮ್ಮ ಫಾದರ್ ಕ್ರಿಮೇಷನ್ ಪ್ಲೇಸ್ಗೆ ಅಂತೇಳಿ. ಹಾಗಾಗಿ ನಮ್ಮ ಹಳೆ ಮೈಸೂರು ಪ್ರಾಂತ್ಯದಲ್ಲಿ ಅವ್ರ ತಂದೆಯಿಂದ ಹಿಡಿದು ಅವರು ಮತ್ತು ಈಗ ಇವರು ಎಲ್ಲ ಈ ಕ್ಷೇತ್ರಕ್ಕೆ ಮಾಡಿರೋ ಸೇವೆ ನಿಜವಾಗಿ ಅಗಾಧವಾದ್ದು ಅಂತ ಹೇಳ್ತಾ ಎರಡೆರಡು ಮಾತಾಡ್ತೀನಿ. ನಾನು ಈ ಯೂನಿವರ್ಸಿಟಿ ಬಗ್ಗೆ ಮಾತಾಡಬೇಕಾದ್ರೆ ಈಶ್ವರ ಭಟ್ರ ಬಗ್ಗೆ ಮಾತಾಡಲೇಬೇಕಾಗತ್ತೆ. ನಾನು ಮಂತ್ರಿ ಆಗಿಲ್ಲ ಈವರೆಗೆ ಒಬ್ಬ ಒಳ್ಳೆ ಮನುಷ್ಯನಿಗೂ ಕೂಡ ಎಷ್ಟು ಸಮಸ್ಯೆಗಳು ಬರಬಹುದು ಅನ್ನೋದಕ್ಕೆ ಅವರೇ ನಿದರ್ಶನ. ಹೇಳ್ತಿದ್ವಿ, ಏನ್ರಿ ಯಾವುದೋ ಕಾಲದ ಕಾಮದೇನೋ ಕಥೆನ ಓದ್ದಂಗೆ ಆಗುತ್ತೆ. ನಿಮ್ಮನ್ನು ಕೇಳ್ತಾ ಇದ್ರೆ ಮುಂದೆ ಬಂದರೆ ರಾಯಬೇಡಿ, ಹಿಂದೆ ಬಂದರೆ ಒದೆಯಬೇಡಿ, ಕಂದ ನಮ್ಮವನೆಂದು ಕಾಣಿರೋ ತಪ್ಪಲೇ ನೀಕರುವನು ಸ್ಟೇಜ್ಗೆ ಸ್ವಲ್ಪ ಡೈನಮಿಕ್ ಆಗಿರಬೇಕಾಗಿತ್ತು ಅಂತ. ವಿತ್ ಆಲ್ ದಿಸ್ ಕೋವಿಡ್ ಅಲ್ಲಿ ಒತ್ತಡಗಳ ಮಧ್ಯೆ ಅವಹೇಳನ ಸಹಿಸಿಕೊಂಡು ಈ ಯೂನಿವರ್ಸಿಟಿ ಉಪ ಕುಲಪತಿಗಳಾಗಿ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಅವ್ರನ್ನ ಅಭಿನಂದಿಸ್ತೀನಿ. ಮತ್ತೆ ಅಂಥವ್ರಿಗೆ ಶಕ್ತಿ ಇರಲ್ಲ, ಆದರೂ ಅನಿವಾರ್ಯ ಆಯಿತು. ನನಗೆ ಸಂತೋಷ ಏನಂದ್ರೆ ನಾನು ಅವ್ರ ಜೊತೆ ಇರ್ಲಿಕ್ಕೆ ಸ್ವಲ್ಪ ಭಗವಂತ ನನಗೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ರು ಅಂತ. ಎರಡನೇದು ಅಕಾಡೆಮಿಕ್ ಆಗಿ ಬಹಳ ಸೌಂಡ್ ಇರೋ ಮನುಷ್ಯ. ಈಶ್ವರ ಭಟ್ರು ನನಗೇನು ಕೊಟ್ಬಿಟ್ಟಿಲ್ಲ. ಬಹಳ ಇಷ್ಟ ಯಾಕೆ ಪಡ್ತೀನಿ ಅಂದರೆ ಅವ್ರ ಬರವಣಿಗೆಗಳು, ಅವ್ರಿಗೆ ಗೊತ್ತಿರುವಂಥ ವಿಷಯಗಳು, ಅದನ್ನು ಹೇಳೋ ರೀತಿ ತುಂಬ ಮೆಚ್ಚುಗೆ. ನಾನು ಇಂಡಿಯನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಮೇಲೆ ಮಾತಾಡಬೇಕಾಗಿತ್ತು. ಈಶ್ವರ ಭಟ್ರೆ ನಾನು ಸ್ವಲ್ಪ ಲಿಟ್ರೇಚರ್ ಬೇಕು ಅಂತ ಹೊರಟ್ರು ಸೀದಾ ಸ್ಮೃತಿ ಶ್ರುತಿ ಅಂತ. ಫಸ್ಟ್ ಟೈಮ್ ಮೇಡಮ್ ಅಸೆಂಬ್ಲಿನಲ್ಲಿ ಸ್ಮೃತಿ ಶ್ರುತಿ ನಾನು ಶುರು ಮಾಡಿಕೊಂಡೆ. ನಮ್ಮ ಈ ಕಡೆ ನಮ್ಮ ಸ್ಪೀಕರ್ ಕೇಳಿದ್ರು, ಏನೇ ನನಗೆ ಸಿಕ್ಕದ್ ನಿಮಗೆ ಸಿಗ್ತಿದೆಲ್ಲ ಹೇಳಾಗಿರಲಿಲ್ಲ. ನಾನು ದಡ್ಡಾಗ್ಬಿಡ್ತಿದ್ದೆ ಹೇಳಿದ್ರೆ ಹಾಗಾಗಿ ಆ ಮೂಲ ಹುಡ್ಕೋದ್ರಲ್ಲಿ ಜೊತೆಗೆ ಒಂದು ಒಳ್ಳೆ ಕೆಲಸ ಅವ್ರು ಮಾಡಿದ್ದು, ಜಡ್ಜ್ಗಳ ಜೊತೆ ನಿಮಗೆ ಬಹಳ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡಿಸಿದ್ರು. ನೋ ಅದರ್ ಯೂನಿವರ್ಸಿಟಿ ಆರ್ ನೋ ಅದರ್ ವೈಸ್ ಚಾನ್ಸಲರ್ ಹ್ಯಾವ್ ಡನ್ ದಿಸ್ ಜಾಬ್. ಸುಮಾರು ವೆಬಿನಾರ್ಗಳಲ್ಲಿ, ಸುಮಾರು ಕಾರ್ಯಕ್ರಮಗಳಲ್ಲಿ ಜಡ್ಜ್ಗಳ ಜೊತೆ ನಮ್ಮ ಮಕ್ಕಳಿಗೆ ಇಲ್ಲಿರೋ ಎಲ್ಲ ಅಕಾಡೆಮಿಷಿಯನ್ಸ್ಗೆ ಇಂಟ್ರಾಕ್ಟ್ ಮಾಡಿಸಿ ನ್ಯಾಯಾಲಯ ಮತ್ತು ಕಾಲೇಜಿನ ಸಂಬಂಧ, ಯೂನಿವರ್ಸಿಟಿ ಸಂಬಂಧನ ಬಹಳ ಹತ್ತತ್ರ ತಂದರು. ಇದೆಲ್ಲ ಅವ್ರು ಮಾಡೋ ಕೆಲಸ. ಇವತ್ತು ವಿಶ್ರಾಂತರಾಗ್ತಿದ್ದಾರೆ. ಭಗವಂತ ಅವ್ರಿಗೆ ಇಲ್ಲಿಂದ ಮುಂದೆ ಹೆಚ್ಚು ಪುಸ್ತಕ ಬರೆಯೋ ಶಕ್ತಿ ಕೊಡಲಿ. ಸಮಾಧಾನ ಇದ್ದರೆ ಒಳ್ಳೊಳ್ಳೆ ಕೃತಿಗಳನ್ನ ನಿರೀಕ್ಷೆ ಮಾಡ್ಬೋದು. ಅದು ಅವ್ರಿಗೆ ಇರಲಿ ಅಂತೇಳಿ ನಾನು ಆಶಿಸ್ಬಿಟ್ಟು ಯೂನಿವರ್ಸಿಟಿ ಬಗ್ಗೆ ಮಾತಾಡಲೇಬೇಕಂದ್ರೆ ಎರಡು ಮಾತಿದೆ. ನಾನು ಅವ್ರಿಗೆ ಹೇಳ್ತಿದ್ದೆ, ಕಾಲೇಜ್ ಆಫ್ ಎಕ್ಸಲೆನ್ಸ್ ಅಂತ ಅನ್ನಿಸ್ಕೊಂಡು ಬೆಂಗಳೂರಲ್ಲಿ ಒಂದಿದೆ, ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಎಕ್ಸಲೆನ್ಸ್ ಅಂತ ಅನ್ನಿಸ್ಕೊಳ್ಳಿಕ್ಕೆ ಒಂದು ಯೂನಿವರ್ಸಿಟಿ ಮಾಡಬೇಕಾಗಿತ್ತು. ನಾವು ಕರ್ನಾಟಕದಲ್ಲಿ 106 ಕಾಲೇಜ್ ಇರೋದೇ ದೊಡ್ಡದಾಗಿ ಹೇಳ್ಕೊಂಡು ಹೋದ್ವಿ. ಎಲ್ಲೋ ಒಂದು ಕಡೆ ನ್ಯಾಷನಲ್ ಕಾಲೇಜ್ ಅಷ್ಟೇ ನಾವು ಮಾಡ್ಬೋದು, ನಮಗೇನು ಕೊರತೆ ಇಲ್ಲ ಅನ್ನೋ ಸ್ಥಿತಿಗೆ ಬಿಟ್ಟರೆ ಒಂದು 4-5 ಕಾಲೇಜ್ ಆದರೂ ನಾವು ತಗೊಂಡು ಹೋಗ್ಬೇಕಲ್ಲ. ನಮ್ಮಿಂದ ಏನು ಬೇಕೋ ಹೇಳಿ, ಗೌರ್ಮೆಂಟ್ ಈಸ್ ಹಿಯರ್ ಟು ಸಪೋರ್ಟ್ ಆ್ಯಂಡ್ ಗಿವ್ ಆಲ್ ಅಸಿಸ್ಟೆನ್ಸ್ ರಿಕ್ವೈರ್ಡ್ ಅಂತ ಪ್ರಯತ್ನಗಳಾಯಿತು. ಮತ್ತು ನಾವೆಲ್ಲೋ ಒಂದು ಕಡೆ ಇದು ಗಾತ್ರ ದೊಡ್ಡದಾಯ್ತು ಅಂತ ಕೂಡ ಯೋಚನೆ ಮಾಡೋಂಥ ಸ್ಥಿತಿ ಬಂತು. ಪರೀಕ್ಷೆಗಳಾಗಬೇಡ ಅಂದಾಗ ನಾನೇ ಭಾಳ ಹಠ ಮಾಡ್ತಿದ್ದೆ ಒಂದು ರಾಜ್ಯ ಸರ್ಕಾರದಲ್ಲಿ, ಯಾವುದೇ ಲಾ ಕಾಲೇಜು ಈ ಯೂನಿವರ್ಸಿಟಿ ವ್ಯಾಪ್ತಿಯಿಂದ ಆಚೆ ಆಗಬಾರ್ದು ಅಂತ. ಮಧ್ಯೆ ಕರೆದು ನಾನು ಅವ್ರಿಗೆ ಹೇಳಿದಿಲ್ಲ, ಬಟ್ ಐ ಹ್ಯಾವ್ ಟು ರಿವರ್ಸ್ ಮೈ ಡಿಸಿಷನ್. ಒಂದಷ್ಟು ಅಟಾನಮಿನ ಡಿಕ್ಲೇರ್ ಮಾಡೋದು ವಾಸಿ ಅನ್ನೋ ಕರ್ನಾಟಕದಲ್ಲಿ. ಏನ್ರಿ ಇದು, ಯಾರೋ 4 ಜನ ಓದ್ದಲೇ ಇರೋರು ಕಲ್ಲಿಡ್ಕೊಂಡು ನಿಂತ್ಕೊಂಡ್ರೆ ಓದಿರೋ ಮಕ್ಕಳೆಲ್ಲ ಈ ಥರ ಕೂತ್ಕೊಂಡು ಮನಸ್ಸನ್ನು ಕೆಳಗೆ ಬಿಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡು ಸ್ಟೇಜ್ನ ನಾವೆಲ್ಲ ತರಬೇಕಾ? ಸಮ್ ಫ್ಯೂ ಪೀಪಲ್. ಯಾಕೆಂದ್ರೆ ನಂಗೆ ಗೊತ್ತು, ಯಾರಾದರೂ ಯೋಧ ಅನ್ನಿಸ್ಕೊಳೋನು ಗಡಿಲಿರೋಕ್ಕೆ ಇಷ್ಟಪಡ್ತಾನೆ. ಯಾರಾದ್ರು ಒಳ್ಳೆ ವಿದ್ಯಾರ್ಥಿ ಅಂದರೆ ಯಾವಾಗ ಎಕ್ಸಾಮಿನೇಷನ್ ಬರುತ್ತಪ್ಪ ಅಂತ ಕಾಯ್ತಿರ್ತಾನೆ. ಚೆನ್ನಾಗಿ ಅಸೆಂಬ್ಲಿ ಮಾತಾಡೋರು ನಾವು ಅಸೆಂಬ್ಲಿ ಬರಲಿಲ್ವಲ್ಲ ಅಂತ ಕಾಯ್ತಿರ್ತೇವೆ. ಏನಾದರೂ ನಾವು ಒಂಚೂರಲ್ಲಿ ಮಿಂಚ್ಬೋದಲ್ಲಪ್ಪ ಅಂತ. ಹಾಗೆ ಸ್ಟೂಡೆಂಟ್ಸ್ಗೆ ಪರೀಕ್ಷೆ ಬಗ್ಗೆ ಹೆಚ್ಚು ಆಸಕ್ತಿ ಇರಬೇಕು, ನನ್ನ ಕೆಪಾಸಿಟಿ ಪ್ರೂವ್ ಮಾಡಬೇಕು ಅನ್ನೋ ಹಂಬಲ ಇರಬೇಕು. ಎವ್ರಿ ಡೇ ಮೇಡಮ್ ಫೋನ್ ಕಾಲು, ಥ್ರೆಟ್ಟು, ಸ್ಟ್ರೈಕು, ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಬೇಡ. ಹೌ ಕ್ಯಾನ್ ದೇ ಬಿ ಗುಡ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಒನ್ ಡೇ? ಬೇರೆ ಯಾವುದೋ ಕ್ಷೇತ್ರಕ್ಕೂ ಈ ಕ್ಷೇತ್ರಕ್ಕೂ ಎಷ್ಟು ವ್ಯತ್ಯಾಸ ಇದೆ. ಮೆಡಿಸಿನ್ ಮತ್ತೆ ಲೀಗಲ್ ಫ್ರೆಟರ್ನಿಟಿನಲ್ಲಿ ನಾವು ಪರೀಕ್ಷೆ ಬೇಡ ಅಂದ್ರೆ ಗತಿ ಏನಂತ ಹೇಳಿ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ. ಆ ವ್ಯವಹಾರದಲ್ಲಿ ಬಹುಶಃ ನಮ್ಮ ಶಾಸನ ಸಭೆಯಲ್ಲಿ ಕೂಡ ವ್ಯಾಪಕವಾಗಿ ಚರ್ಚೆ ಆಯ್ತು. ಬಹಳ ಒತ್ತಡ ನನಗೆ ಬಂತ. ಐ ಸೆಡ್ ನಥಿಂಗ್ ಡೂಯಿಂಗ್, ನೋ ಎಕ್ಸಾಮಿನೇಷನ್, ನೋ ಡಿಗ್ರಿ. ಯಾರು ಏನ್ ಮಾಡ್ತಿರೋ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದು ಇದೆ. ಬೆಳಗಾಮಲ್ಲೇ ಒಂದೇ ವರ್ಡಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟೆ ನಾನು ಅವತ್ತು. ಹಾಗಾಗಿ ಅವ್ರು ಫೋನ್ ಮಾಡಿದ್ರು, ಸರ್ ಇಷ್ಟು ಡೈರೆಕ್ಟ್ ಹೇಳ್ತಿರಿಂದ ನಾವು ಹಾಗೆ ಬಿಡ್ರಿ, ನಾವು ಯಾವ್ದು ಕಂಡುಕೊಂಡು ಹೋಗಲ್ಲ. ಹಾಗಾಗಿ ನಾವೆಲ್ಲ ಒಂದ್ ಕಡೆ ಕಲ್ತ್ಕೋಬೇಕು. ನಾನು ಅವತ್ತು ಅವ್ರಿಗೆ ಹೇಳಿದೆ, ಮೇಡಮ್ ಹೇಳಿದ್ರ ಜೊತೆಗೆ ನಾನು ಸೇರಿಸ್ತೀನಿ. ಈ ಡೆಮಾನ್ಸ್ಟ್ರೇಷನ್ ಸ್ಕೂಲ್ಸ್ ಕಾನ್ಸೆಪ್ಟ್ ಅಂತ ಅಂದ್ಬಿಟ್ರೆ ಒಳ್ಳೇದ. ಎವ್ರಿ ಡೇ ಎವ್ಯಾಲ್ಯೂಯೇಷನ್, ಎವ್ರಿ ಡೇ ಅವಾರ್ಡಿಂಗ್ ಮಾರ್ಕ್ಸ್. ಕೊನೆಯಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಅದನ್ನೆಲ್ಲ ಟೋಟಲ್ ಮಾಡಿ ನೀನು ರಿಸಲ್ಟ್ ಕೊಡ್ತೀನಿ ಅನ್ನೋ ಸ್ಥಿತಿ ತಂದ್ರೆ ಸ್ವಲ್ಪ ಇದಕ್ಕೆಲ್ಲರೂ ಪರಿಹಾರ ಸಿಗ್ಬೋದಾ ಅಂತ. 2 ಮೇಡಮ್ ರೋಬೋಟ್ ಪದ ಬಳಸಿದ್ರು. ನಾನು ಮೊನ್ನೆ ಇಂಡಸ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಅಂತ ರೋಬೋಟ್ ಟೀಚಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಬೆಂಗಳೂರು. ನಾನು ಹ್ಯಾಡ್ ಬೀನ್ ಟು ದಟ್ ಸ್ಕೂಲ್. ಆ ಸ್ಕೂಲ್ಗೆ ಹೋಗಿದ್ದೆ. ನಾನು ಕೊಂಡಿಸ್ಕೊಂಡವರು ಚಿಕ್ಕ ಮಕ್ಕಳಿಂದ ಹಿಡಿದೆಲ್ಲರಿಗೂ ರೋಬೋಟಲ್ಲಿ ಟೀಚಿಂಗ್ ಏನು ಮಾಡ್ಬೋದು, ಹೆಂಗೆ ಮಾಡ್ಬೋದು, ಪ್ರಶ್ನೆ ನಾವೇನು ಕೇಳ್ಬೋದು, ರೋಬೋಟ್ ನಮ್ಮನ್ನೇನು ಪ್ರಶ್ನೆ ಕೇಳುತ್ತೆ ಅಂತೇಳಿ ಎಲ್ಲ ಮಾಡಿ ತೋರಿಸಿದ್ ನನಗೆ. ಆ್ಯಂಡ್ ಅದೇ ಬಯಾಲಜಿನ ಚಾಪ್ಟರ್ ತೊಗೊಂಡು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಇನ್ ಪ್ಲಾಂಟ್ಸ್ ಅನ್ನೋದನ್ನು ತಗೊಂಡು ಹುಡುಗರಿಗೆ ಪಾಠ ಮಾಡ್ತಿದ್ರು. ನಾನು ಅವ್ರಿಗೆ ಕೇಳಿದೆ, ವೈ ನಾಟ್ ವಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ದಿಸ್ ಇನ್ ಲಾ ಕಾಲೇಜಸ್ ಅಂತ. ಮಾಡ್ಬೋದು ಸರ್, ಇಫ್ ಯು ಅಗ್ರಿ ವಿಲ್ ಇದನ್ನು ಮಾಡಿಫೈ ಮಾಡಿ ಏನಾದ್ರು ಮಾಡ್ತೀವಿ ಅಂತ. ಬಟ್ ಈಗ ನನಗೆ ಅವ್ರಿಗೊಂದು ಒಪ್ಪಂದ ಆಗಿದೆ, ನಮ್ಮ ಹಳ್ಳಿನಲ್ಲಿ ಚಿಕ್ಕ ಮಕ್ಕಳಿಗೆ, ಬಡವ್ರ ಮಕ್ಕಳಿಗೆ ರೋಬೋಟ್ ಟೀಚಿಂಗ್ ಫಸ್ಟ್ ಮಾಡಿ ಆನಂತರ ಏನಾದ್ರು ನಿಮ್ಗವ್ರಿಗೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ ಅಂತ ನಾವು ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ವಿ. ಅದು ಎಲ್ಲರೂ ಒಂದ್ ಕಡೆ ಬಂದ್ರೆ ಸ್ವಲ್ಪ ಮಟ್ಟಿಗೆ ಡಿಜಿಟಲೈಸೇಷನ್ ಜೊತೆಗೆ ನಾವು ಆನ್ಲೈನ್ ಟೀಚಿಂಗ್ ಜೊತೆಗೆ ರೋಬೋಟು ಏನಾದ್ರು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೋದಾ ಟೀಚಿಂಗಿಗೆ ಅಂತೇಳಿ ಯೋಚನೆ ಮಾಡ್ತೀವಿ. ಲಾಟ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಅದಕ್ಕೆ ನಾವು ಫೀಡ್ ಮಾಡಿರ್ತೀವಿ. ಅದು ಪ್ರಶ್ನೆ ಕೇಳುತ್ತೆ, ಉತ್ತರ ಹೇಳುತ್ತೆ, ಕರೆಕ್ಷನ್. ಮೇಡಮ್ ಅಲ್ಲೂ ಕೂಡ ಅಷ್ಟೇ, ಒಂದು ಚಾಪ್ಟರ್ ತಗೊಂಡು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ ಪ್ರಶ್ನೆ ಕೇಳಿ ಆ ಕ್ಷಣದಲ್ಲಿ ಎವ್ಯಾಲ್ಯೂಯೇಟ್ ಮಾಡಿ ಮಾರ್ಕ್ಸ್ ಕೊಟ್ಬಿಡುತ್ತೆ. ವಿ ನೀಡ್ ನಾಟ್ ವೇಟ್ ಫಾರ್ ದಿ ಫೈನಲ್ ರಿಸಲ್ಟ್ಸ್ ಟು ಕಮ್. ನಾನು ನಿನ್ನೆ ನಮ್ಮ ರಾಜ್ಯಸಭಾ ಎಲೆಕ್ಷನ್ ಹೇಳ್ತಿದ್ದೇನೆ, ಎಲ್ಲ ಓಪನ್ ಬ್ಯಾಲೆಟ್ ಅಪ್ಪ, ಓಟ್ ಹಾಕುವಾಗಲೇ ಬರ್ಕೊಂಡು ಕೂತಿದ್ರೆ 5:30 ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗೋದು, ಏನ್ರಿ ಕತೆ ಇದು ಅಂತ. ಹಾಗೆ ಅಲ್ಲೇ ಎವ್ಯಾಲ್ಯೂಯೇಷನ್ ರಿಪೋರ್ಟ್ ವಿತಿನ್ 2 minutes ನಿಮಗೆ ಮಾರ್ಕ್ಸ್ ಬರುತ್ತೆ, ಯಾವ್ದು ಸರಿ ಯಾವ್ದು ತಪ್ಪು ಪ್ರಿಂಟ್ಔಟ್ ಬಂದ್ಬಿಡುತ್ತೆ. ಹಾಗೆ ಏನಾದ್ರು ಲಾ ಯೂನಿವರ್ಸಿಟಿಲಿ ಮಾಡ್ಬೋದ ಅಂತ ಮಾತಾಡಿದ್ದೇನೆ. 3ನೇದು ನನಗೀಗ ಬಹುಶಃ ನಿಮಗೆ ಗೊತ್ತು, ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸಿನರಿಯೋ ಇಸ್ ಚೇಂಜ್, ಬಹಳ ಬದಲಾಗ್ತಾ ಇದೆ. ಕಾಮನ್ವೆಲ್ತ್ ಅಥವಾ ಏನು ನಾವು ನಮ್ಮ ಯುರೋಪಿಯನ್ ಕಂಟ್ರೀಸ್ ಅಮಾಲ್ಗಮೇಷನ್ ಇತ್ತು, ಸ್ವಲ್ಪ ಡಿಸ್ಇಂಟಿಗ್ರೇಟ್ ಆಗಿದೆ. ಅಲ್ಲಿ ಈಗ ಲೀಗಲ್ ಅಸಿಸ್ಟೆನ್ಸು, ಲೀಗಲ್ ಫ್ರೆಟರ್ನಿಟಿಗೆ ಭಾರಿ ಗೊತ್ತಿದೆ. ನನ್ನ ಹತ್ರ ಗ್ರೀಸ್ ಅಂಬಾಸಿಡರ್ ಬಂದಿದ್ರು. ಕ್ಯಾನ್ ಯು ಹ್ಯಾವ್ ಎ ಕೋರ್ಸ್ ಟು ಟೀಚ್ ಇಂಡಿಯನ್ ಲಾಸ್ ಟು ಗ್ರೀಸ್ ಪೀಪಲ್? ವಿ ಹ್ಯಾವ್ ಸಮ್ 700-800 ಇನ್ ಬ್ಯಾಂಗ್ಳೂರ್. ನಾನು ಇದನ್ನ ಇಂಟರ್ಚೇಂಜ್ ಆಕ್ಟಿವಿಟಿ ಮಾಡ್ಬೋದಾ, ನನಗೊಂದು ಮಾಹಿತಿ ತಂದು ಕೊಡಿ. ನಮ್ಮ ಮಕ್ಳು ಏನಾದರೂ ಅಲ್ಲಿಲ್ಲ ಓದೋದು, ನಿಮ್ಮ ಇಲ್ಲಿಗೆ ಬರೋರು ಸ್ವಲ್ಪ ಮಾಡೋದು. ಆಗ ನಾವು ಒಂದು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಬಂದು ಒಂದು ಕೌನ್ಸಿಲಿಂಗ್ ಸೆಂಟರ್ ಆದರೂ ಮಾಡಬೇಕು. ಫ್ರಮ್ ದಿ ಪಾಯಿಂಟ್ ಆಫ್ ಇಮಿಗ್ರೇಷನ್ ಟು ದೇರ್ ಸ್ಟೇ ಇನ್ ದಟ್ ಕಂಟ್ರಿ, ಇಲ್ಲಿಂದ ಹೋಗೋಕೆ ಮೊದಲೇ ನಾವು ಅವ್ರಿಗೆ ಏನಾದರೂ ಟೀಚ್ ಮಾಡಿ ಕಳಿಸ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ? ಸೊ ಕ್ಯಾನ್ ವಿ ರೀಸ್ಟಾರ್ಟ್ ದಿ ಸ್ಟಡಿ ಆಫ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾಸ್ ಕಂಟ್ರಿ ಬೈ ಕಂಟ್ರಿ ಮೇಡಮ್, ನಾಟ್ ಓನ್ಲಿ ಟ್ರೇಡ್, ನಾಟ್ ಓನ್ಲಿ ಟ್ರೀಟೀಸ್. ಅಲ್ಲಿಯ ಬೇಸಿಕ್ ಕ್ಲಾಸ್ ನಾರ್ಮಲ್ ಲೈಫ್ಗೆ ಏನು ಕಾನೂನುಗಳು ಬೇಕು ಅದನ್ನೆಲ್ಲಾದರೂ ಶುರು ಮಾಡೋ ಒಂದು ಸ್ಥಿತಿನ ನಾವು ಕರ್ನಾಟಕದಲ್ಲಿ ಮಾಡಬೇಕಾ? ನಾವೀಗ ಹೊರಟಿದ್ದೀವಿ, ಮೇಡಮ್ ಅವರು ನಾವು ಮಾತಾಡ್ತಾ 18ನೇ ತಾರೀಕು ನಾವು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಂಟ್ರಿಗೆ ಫೌಂಡೇಶನ್ ಲೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ವಿ ಆರ್ ಗೋಯಿಂಗ್ ಟು ಹ್ಯಾವ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಸೆಂಟರ್ ಅಟ್ ಬ್ಯಾಂಗ್ಳೂರ್. ಹಾಗೆಯೇ ಕೌನ್ಸಿಲಿಂಗ್ ಸೆಂಟರ್ ಒಂದು ಮಾಡ್ಬೋದು, ಆ ಕರ್ನಾಟಕದಲ್ಲೇ ಮಾಡಿಬಿಟ್ಟು ಯಾರು ಹೋಗ್ತಾರೆ ಅಮೆರಿಕಾದಲ್ಲಿ ಇರ್ತೀವಿ ಅಂತ ಹೋಗೋರಿಗೆ, ಫ್ರಾನ್ಸಲ್ಲಿ ಇರ್ತೀವಿ ಅಂತ ಹೋಗೋರಿಗೆ. ಯಾಕೆಂದರೆ ಎಲ್ಲೋ ಒಂದು ಕಡೆ ಲಾಸ್ ಆರ್ ನಾಟ್ ನೋನ್ ಟು ಅಸ್. ಅಲ್ಲಿಗೆ ಹೋಗೋರಿಗೆ, ಅಲ್ಲಿ ಅಕ್ವೈಂಟ್ ಆಗೋರಿಗೆ ನಮ್ಗೆ ಅಲ್ಲಿದ್ದು ಏನೂ ಗೊತ್ತಿರಲ್ಲ. ದಿಢೀರಂತ ಹೋಗ್ತೀವಿ, ವಿಲ್ ಬಿ ಕೆಪ್ಟ್ ಇನ್ ಡಾರ್ಕ್ನೆಸ್ ಫಾರ್ ಫ್ಯೂ ಡೇಸ್. ಅದೇನು ಗೊತ್ತಾಗಲ್ಲ, ಇದೇನು ಗೊತ್ತಾಗಲ್ಲ. ಆಸ್ ಸಚ್ ಅನ್ಎಜುಕೇಟೆಡ್ ಅನ್ನೋ ಸ್ಥಿತಿನಲ್ಲಿ ನಾವು ಅಲ್ಲಿ ಬದುಕಬೇಕಾಗತ್ತೆ. ಅದಕ್ಕೆ ಮೊದಲೇ ಏನಾದ್ರು ನಮ್ಮ ಕಾಲೇಜ್ಗಳಲ್ಲಿ ಅಲ್ಲಲ್ಲೇ 1-2 ಸೆಂಟರ್ಗಳು ಮಾಡಿ ಈ ಕೋರ್ಸ್ ಒಂದನ್ನು ಯಾರಾದರೂ ಒಂದು ಕಂಡೆನ್ಸ್ಡ್ ಕೋರ್ಸಸ್ 10 days, 15 days, 1 month, starting from a boy who wants to move out of the country to his family members, ಸಣ್ಣ ಪುಟ್ಟ ಈ ಕಾನೂನುಗಳು ಪರಿಚಯ ಮಾಡಿಕೊಡ್ಬೇಕು. ಒಂದು ಅಲ್ಲಿಂದ ಬರೋರ್ಗು ಹೇಗಾದ್ರೂ ಮಾಡಿ ಒಂದು 15 ದಿವಸ, ನಾವೀಗ ಕೋವಿಡ್ ಬಂದಾಗ ಕ್ವಾರಂಟೈನ್ ಮಾಡ್ತಿದ್ವಿ, ಅಪ್ಪ ಅಲ್ಲೊಂದು 15 ದಿವಸ ಇದ್ದ ಆಮೇಲೆ ಬಂತ. ಹಾಗೆ ಒಂದು 15 ದಿವಸ ಇದ್ಬಿಟ್ಟು ನಮ್ಮ ಲಾಗಳೆಲ್ಲ ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಬಾರಪ್ಪ ಅಂತೇಳಿ ಒಂದು ಸಣ್ಣ ಕ್ವಾರಂಟೈನ್ ಮಾಡ್ಬೇಕಾ ಅಂತ ಒಂದು ಆಲೋಚನೆ ಕೂಡ ನಾವು ಆಲೋಚನೆ ಮಾಡಿ ಒಂದು ಚರ್ಚೆ ಮಾಡ್ತಾ ಇದ್ವಿ. ಮೊನ್ನೆ ನಮ್ಮ ಮೊರಾಕೋ ಹೆಣ್ಮಗಳು ಒಂದು IT ಮಿನಿಸ್ಟ್ರು ಬಂದು, ನಾನು ಅವತ್ತೇ ಗ್ರಾಚಾರ್ಯಕ್ಕೆ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಟೀಮ್ ಜೊತೆ ಮಾತಾಡಿ ಅವ್ರನ್ನ ಕಳಿಸಿ ಈಕೆಗೆ ಬಹುಶಃ ವೆಂಕಟೇಶ್ ನಾಯಕ್ ವಾಸ್ ದೇರ್. ನಾನು CM ಅವರು ನನ್ನ ಮನೆಯಲ್ಲೇ ಹೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದಟ್ ಲೇಡಿ ಆಸ್ಕ್ ಮೀ, ಸರ್ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಸಮಥಿಂಗ್ ಟು ನೋ ದಿ ಲಾಸ್ ಆಫ್ ದಿಸ್ ಕಂಟ್ರಿ ಅಂಡ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾಸ್. ನೀವು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಏನಾದ್ರು ಅಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕಾಗುತ್ತಾ ಅಂತ ನಾನು ಪ್ರಪೋಸ್ ಮಾಡಿದೆ. ಕ್ಯಾನ್ ವಿ ಸ್ಟಾರ್ಟ್ ಎ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಇನ್ ಮೊರಾಕೋ? ಈ ಉಕ್ರೇನ್ದೆಲ್ಲ ಆದಮೇಲೆ ನಮ್ಮ ಮಕ್ಳಿಗೆ ಈಗ ಇಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಕೊಡೋಕೆ ಆಗ್ತಾ ಇಲ್ಲ. ದೇ ಆರ್ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಟು ಸ್ಟಡಿ ಮೆಡಿಸಿನ್ ಇಯರ್. ಬಾಯ್ ತುಂಬ ಸಿಂಪತ್ ಹೇಳ್ಬಿಟ್ಟು ಉಕ್ರೇನ್ ಆದಮೇಲೆ ವಾಪಸ್ ಬಂದವ್ರಿಗೆ ಅಕಾಮಡೇಟ್ ಮಾಡಿ. ಹೌ ಕ್ಯಾನ್ ವಿ ಅಕಾಮಡೇಟ್? ಮೆರಿಟಲ್ಲಿ ಇಲ್ಲ, ನೀಟ್ ಬರೆದಿಲ್ಲ, ಪರೀಕ್ಷೆನಲ್ಲಿ ಅವ್ರು ಏನಿದ್ರು ಅಂತಿದ್ರು ಗೊತ್ತಿಲ್ಲ. ಹಾಗಾಗಿ ನಮ್ಮಲ್ಲಿ ಮೆರಿಟಲ್ಲಿ ಹುಡುಗರಿಗೆಲ್ಲ ನೀಟಲ್ಲಿ ನಾವು ಸುಮ್ಮನೆ ಕೂರಿಸ್ಬಿಟ್ಟು ಅವ್ರು ಆಚೆಯಿಂದ ಬಂದ್ರು ಅಂತ ಡಿಗ್ರಿ ಕೊಡೋಕೆ ಹೇಗಾಗುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಮಗೆ. ಹಾಗಾಗಿ ಆಸ್ತೆ ಏನೇನು ಮಾಡ್ಬೋದು ಎಜುಕೇಷನ್ ಫೀಲ್ಡಲ್ಲಿ ಅಂತ ನಾನು CM ಅಶ್ವಥ್ ನಾರಾಯಣ್ 3 ಜನ ಇದ್ವಿ. ನೋಡಮ್ಮ, ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಏನಾದರೂ ಬೇಕಾದ್ರೆ ಕ್ಯಾನ್ ಆಸ್ಕ್ ಸಮ್ ಅವರ್ ಪೀಪಲ್, ದೀಸ್ ಆರ್ ಆಲ್ ಓನರ್ಸ್ ಆಫ್ ದಿ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಆಫ್ ದಿ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್, ವಿ ಕ್ಯಾನ್ ಆರ್ಗನೈಸ್ ಅಂದ್ವಿ. She agreed. Suddenly she asked, can you start a law college also? Why not? Why not? We can have a law college in those countries also. ಅಲ್ಲಿ ಮಕ್ಕಳು ಬಂದು ಇಲ್ಲಿ ಓದೋದು, ಒಂದು 50 ಜನ 60 ಜನ ಏನಾದ್ರು ಒಂದು ಕೋರ್ಸ್ ಮಾಡಿ ಈ ಕಡೆ ಕೂಡ ನಮ್ಮ ಲಾನ ಹೇಳ್ಕೊಡ್ಲಿಕ್ಕೆ, ಆ ಮಕ್ಕಳಿಗೆ ಯಾರು ಎಂಟರ್ಪ್ರೂನರ್ಸ್ ಇರ್ತಾರೆ ಅಥವಾ ಯಾರು ಆಚೆ ಕಡೆ ಹೋಗಿ ಬದುಕ್ತೀವಿ ಅನ್ನೋ ತೀರ್ಮಾನ ಮಾಡಿರ್ತಾರೆ, ಅಂಥವ್ರಿಗೆಲ್ಲಾದರೂ ಕೋರ್ಸಸ್ ಅನ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೋದಾ ಅನ್ನೋ ಒಂದು ಪಾಸಿಬಿಲಿಟೀಸ್ ಅನ್ನು ಕೂಡ ನಾವು ವರ್ಕೌಟ್ ಮಾಡಬೇಕಾಗಿದೆ. ಹಾಗಾಗಿ ನಾವು ವಿಶ್ವ ಬಹಳ ಚಿಕ್ಕದಾಗ್ತಾ ಇದೆ. ಎಲ್ಲಿ ಹೋಗ್ತೀವಿ, ಯಾವಾಗ ಹೋಗ್ತೀವಿ ಗೊತ್ತಿಲ್ಲ. ಅಮೆರಿಕ ಅಂದ್ರೆ ಅಷ್ಟು ದೂರ ಅಂತಿದ್ವಿ, ಈಗ 12 ಗಂಟೆ ಇತ್ತು. ಇನ್ನೂ ಸ್ಪೀಡಾಗಿ ಹೋಗೋ 10 ಗಂಟೆಗೆ ಪ್ಲೇನ್ ರೀಚ್ ಆಗ್ತೇವೆ ಅಂತ ಚರ್ಚೆಗೆ ಬಂದಿದ್ವಿ. ಹಾಗಾಗಿ 10 ಗಂಟೆಗೆ ನಾವು ರೀಚ್ ಆಗೋ ರಾಷ್ಟ್ರದ್ದು ಬದುಕನ್ನು ತಿಳ್ಕೊಂಡಿರ್ಬೇಕಾಗತ್ತೆ, ಅಲ್ಲಿ ವ್ಯವಸ್ಥೆನೂ ತಿಳ್ಕೊಂಡಿರ್ಬೇಕಾಗತ್ತೆ. ಬದುಕೋದು ಅಂದ್ರೆ ಲಾಸ್ ಆಫ್ ದಟ್ ಲ್ಯಾಂಡ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಂಡರ್ಸ್ಟುಡ್ ಫಸ್ಟ್. ಹಾಗಾಗಿ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಸಿಸ್ಟಮ್ ಅನ್ನು ನಾವು ದೊಡ್ಡದು ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ಒಳ್ಳೇದಾಗುತ್ತೆ. ಹೊಸ ಆಯಾಮಗಳನ್ನ ಮಕ್ಕಳಿಗೆ ಕಲಿಸ್ಕೊಡೋದು, ಹೊಸ ಕೋರ್ಸ್ಗೆ ನಿಮ್ಮನ್ನು ಎಕ್ಸ್ಪೋಸ್ ಮಾಡಬೇಕಾಗತ್ತೆ. ದೇ ಮೇ ನಾಟ್ ಬಿ ಹೆಲ್ಪ್ಫುಲ್ ಫಾರ್ ದಿ ಪ್ರಾಕ್ಟೀಸ್ ಪರ್ಪಸ್ಗೆ ಹೆಲ್ಪ್ಫುಲ್ ಅಂತ ನಾನು ಅನ್ನಲ್ಲ. ಯಾಕಂದ್ರೆ ನಾನೇ ಬೈತಿದ್ದೆ, ಯಾರೋ ನಮ್ಮ ಕಸಿನ್ ಒಬ್ಳು ಇಂಟರ್ನ್ಯಾಷನಲ್ LLM ಮಾಡಿದೆ ಅಂತ ಬಂದಾಗ, ನೀನು ಬೇರೆ ಉದ್ಯೋಗಗಳಿಲ್ವ ನಿನಗೆ, ಯಾಕೆ ನೀನು ಹೋಗ್ಬಿಟ್ಟು ಮೆಡಿಸಿನ್ನಲ್ಲಿ ನಾನ್ ಕ್ಲಿನಿಕಲ್ ಕೋರ್ಸ್ ಮಾಡಿದೆ, ನಾನು ಪೆಥಾಲಜಿ ಓದ್ಕೊಂಬಂದೆ ಅಂದ್ರೆ ಹೆಂಗೋ, ನೀನು ಇಲ್ಲಿ ಕರ್ನಾಟಕದಲ್ಲಿರೋ ನೀನು ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾ ಪಾಸ್ ಮಾಡ್ಕೊಂಬಂದ್ರೆ ಅಷ್ಟೇ, ಯಾವುದು ಕೋರ್ಸ್ ಸಿಕ್ಕಿಲ್ಲ, ನೀನು ಸೇರಿದೆ ಬಿಡಮ್ಮ ಮೈಸೂರಲ್ಲಿ. ಹಾಗಾಗತ್ತೆ. ಹಾಗಾಗದೇ ಇದ್ರು ಒಂದೊಂದೊಂದೊಂದು ಬ್ರ್ಯಾಂಚನ್ನು ನಾವೆಲ್ಲರೂ ಮಾಡಲೇಬೇಕಾಗಿದೆ. ಮತ್ತೆ ಮೇಡಮ್ ಭಾಳ ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ದಾರೆ, ಹೌ ಪ್ರಾಕ್ಟೀಸ್ ಕ್ಯಾನ್ ಬಿ ಎನೇಬಲ್ಡ್ ವಿತ್ ಎಜುಕೇಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಅಂತ. ಐ ಸರ್ಟನ್ಲಿ ಅಗ್ರಿ. ನಾವೆಲ್ಲ ಅಷ್ಟೇ, ನಾವೆಲ್ಲ ಕಾಲೇಜಲ್ಲಿ ಇದ್ದಾಗ ನಮ್ಗೆ ಯಾರು ಲೆಕ್ಚರರ್ಸು ಪ್ರೊಫೆಸರ್ ಇರ್ತಿರ್ಲಿಲ್ಲ. ಕಾಲೇಜಿಂದ ಲಾಯರ್ಗಳೇ ಬಂದು ಹೇಳೋರು, ಅವ್ರು ಏನು ಹೇಳೋರು, ಒಟ್ಟು ನಾವೆಲ್ಲ ಕಲ್ತಿದ್ದೀವಲ್ಲ. ಆ್ಯಂಡ್ ದಟ್ ಈಸ್ ದಿ ನಾಲೆಡ್ಜ್ ಔಟ್ ಆಫ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ನಾಲೆಡ್ಜ್ ಇಸ್ ಗ್ರೇಟ್, ನಾಲೆಡ್ಜ್ ಭಾಳ ಶ್ರೇಷ್ಠ. ನಾಲೆಡ್ಜ್ ಅಕ್ವೈರ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ದೇರ್ ಆರ್ ಮೆನಿ ways and rules to gain knowledge, but knowledge out of experience is not comparable to any other knowledge. ಆ ನಾಲೆಡ್ಜ್ಗೆ ಹೋಲಿಕೆ ಇಲ್ಲೇ ಇಲ್ಲ. ಹಾಗಾಗಿ ಅವ್ರ ಅನುಭವ ಇರೋರು ಬಂದು ಹೇಳೋದು, ನಾವು ಇವೆರಡು ಕೋರ್ಸು, ನಾನು ಐ ಯೂಸ್ ಟು ಕಂಪೇರ್ ದೀಸ್ ಟು ಮೆಡಿಸಿನ್ ಆ್ಯಂಡ್ ಲಾ. ಇದೆರಡು ಕಾಲೇಜಲ್ಲಿ ಕಲಿಯೋದಕ್ಕಿಂತ ಸ್ಪಾಟಲ್ಲಿ ಕಲಿಯೋದೇ ಜಾಸ್ತಿ. ನೀವು ಇಲ್ಲಿ ಏನು ಓದ್ಕೊಂಡು ಹೋಗ್ತೀರಿ, ಇದೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಪ್ರಯೋಜನಕ್ಕೆ ಬರುತ್ತೆ ಅಂತ ನೀವು ಯಾರು ತಿಳ್ಕೊಬೇಡ್ರಿ. Here we are molding you. We are choosing the raw material. Can it be molded ಟು ಎನ್ ಐಡಲ್ ಆರ್ ನಾಟ್ ಅಷ್ಟೇ ನೋಡೋದು ನಾವು. ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ನೀವು ವಿಗ್ರಹ ಹಾಕ್ಬೇಕಂದ್ರೆ ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಹೊಡಿತಾರಲ್ಲ ಜಡ್ಜ್ಗಳು, ಸುತ್ತಿಗೆ ತಗೊಂಡು ಉಳಿ ತಗೊಂಡು, ಆ ಹೇಟಲ್ಲಿ ನೀವು ಮೂರ್ತಿಗಳು ಹಾಕ್ಬೇಕು. ಈವನ್ ಮೆಡಿಸಿನ್ ಇಸ್ ಲೈಕ್ ದಟ್. ಹಾಸ್ಪಿಟ್ಲಲ್ಲಿ ಕಲಿಯೋದೇ ಮೆಡಿಸಿನ್. ಹಾಗಾಗಿ ಅವ್ರ ಮಾತನ್ನ ಕೊನೆಯದನ್ನ ನಾನು ನಿಜವಾಗ್ಲೂ ಭಾಳ ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಿದೆ. 1 ಇಯರ್ ಕೋರ್ಸ್ ನಿಮಗೆ ಎಲ್ಲಾದರೂ ಕೋರ್ಟ್ಗಳ ಮಧ್ಯೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಲಿಕ್ಕೆ ಇದ್ಕೊಂಡು ಎವ್ಯಾಲ್ಯೂಯೇಟ್ ಮಾಡಿ ಅದನ್ನೇನಾದ್ರು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗದೆ ಇದ್ರೆ ನಾವು ಅಲ್ಲೇ ಈಗ ಹೌಸ್ಮನ್ಶಿಪ್ ಕೊಟ್ಟಾಗೆ ಮೆಡಿಕಲ್ ಸ್ಟೂಡೆಂಟ್ಸ್ಗೆ ಕೊಟ್ಟು ತಿದ್ದುಬಿಟ್ರೆ, ಮೇಡಮ್ ಡೋಂಟ್ ಮಿಸ್ಟೇಕ್ ಮೀ, ನಾನು ಹೇಳ್ತೀನಿ, ನೀವು ಇನ್ಯಾರೋ ಸೀನಿಯರ್ ಕೆಳಗೋಗಿ 10-15 ವರ್ಷ ಜೂನಿಯರ್ ಆಗಿರೋದು ತಪ್ಪಬಹುದಾ ಅಂತ. ಯಾಕೆಂದ್ರೆ ಇದು ತಪ್ಪಿಸ್ಬೇಕ್ರಿ, ನನ್ನ ವಿನಲ್ಲಿ ತಪ್ಪಬೇಕಿದು. 1 or 2 years ಅಲ್ಲಿ ಏನೋ ಆಫೀಸ್ ಬಿಟ್ಬಿಟ್ಟು ನಾನು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿದ್ದೀನಿ ಅಂದರೆ ಖುಷಿ ಆಗುತ್ತೆ. 10, 15, 20 ವರ್ಷ ಆದರೂ ಜೂನಿಯರ್ಗಳೇ ನಮ್ಮ ಲಾಯರ್. ಯಾಕಯ್ಯ ಏನು ಮಾಡೋದು ಸರ್ ಅಂತ. ಹಾಗಾಗಿ ಬೇರೆಯವ್ರ ಹತ್ರ ಏನು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಕ್ಲರಿಕಲ್ ಕೆಲಸ ಮಾಡೋ ಆಫೀಸಲ್ಲಿ ಕೂತ್ಕೋತೀವಿ. ಆ ಕೆಲಸ 1 ವರ್ಷ ಏನಾದರೂ ನಾವೇ ಏನಾದ್ರು ಮಾಡಿ ನಿಮ್ಮನ್ನ ಬೇರೆ ಬೇರೆ ಕೋರ್ಟಿಗೆ ಕಳ್ಸೋದು, ಅಲ್ಲೇನಾದರೂ ಅಲ್ಲಿರೋ ಜಡ್ಜ್ಗಳಿಗೆ ಹೇಳಿ ಒಂದು ಟ್ರಯಲ್ ಮಾಡಲಿಕ್ಕೆ ಏನಾದ್ರು ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮ್ಗೆ ಅವಕಾಶ ಕೊಡಿಸೋದು, ಸರಿಯೋ ತಪ್ಪೋ ಅವ್ರ ಕೈ ತಿರ್ಸೋದು, ಈ ಕೆಲಸ ಕೂಡ ಆರಂಭ ಮಾಡೋದು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಪ್ರೊಫೆಷನ್ಗೆ ಭಾಳ ಹೆಲ್ಪ್ ಆಗ್ಬೋದು ಅನ್ನೋದು ನನ್ನ ಅಭಿಪ್ರಾಯ. ಮತ್ತು ಈ ಭಾಗ ಮಾಡ್ಬಿಡ್ಬೇಕು ಮೇಡಮ್. ಯಾರು ಕಾರ್ಪೊರೇಟ್ ಸೆಕ್ಟರ್ಗೆ ಹೋಗ್ತಾರೆ, ಯಾರು ಪ್ರಾಕ್ಟೀಸ್ಗೆ ಹೋಗ್ತಾರೆ, ಎಲ್ಲರೂ ಫೈನಲ್ ಇಯರ್ ಬರೋದ್ರೊಳಗೆ ನಾವೇ ಕೂತ್ಕೊಂಡು ಅದನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಬೇಕು. ನಾನು ನಿಮಗೆ ಗೊತ್ತಲ್ಲ, ನೀವೇ ಇದಿರೋ ಸಾಕ್ಷಿ, ಮೈನ್ ಕ್ರಿಟಿಕ್ ಆಫ್ ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್. ಅವತ್ತು ನಿಮಗೆ ಹೇಳಿದೆ ನಾನು, ನೀವು CJ ಒಬ್ಬನು ಕೋರ್ಟಿಗೆ ಬರಲ್ಲ ಮೇಡಮ್. ಅವ್ರು ದೊಡ್ಡ ಸಂಸ್ಥೆಲಿ ಹೋದವ್ರೆಲ್ಲ ಕಂಪ್ನಿಗಳಿಗೆ ಹೋಗಕ್ಕೆ ನ್ಯಾಷನಲ್ ಲಾ ಸ್ಕೂಲ್ ಇಟ್ಕೊಂಡು ಕರ್ನಾಟಕದಲ್ಲಿ ಅಂತ. ನಾಟ್ ಈವನ್ 10% ಆರ್ ಕಮಿಂಗ್ ಫಾರ್ ಪ್ರಾಕ್ಟೀಸ್. ವಿ ಸೇ ಇಟ್ಸ್ ಎ ಕಾಲೇಜ್ ಆಫ್ ಎಕ್ಸಲೆನ್ಸ್, ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಎಕ್ಸಲೆನ್ಸ್, ಬಟ್ ನೋಬಡಿ ಈಸ್ ಜಾಯ್ನಿಂಗ್ ದಿ ಪ್ರೊಫೆಷನ್. ಅದನ್ನು ನಾವು ಯಾತಕ್ಕೆ ತಯಾರು ಮಾಡಿದ್ವಿ ಅಂದರೆ, ಒಂದು ಕಡೆಲ್ಲ ಕಂಪ್ಯೂಟರ್ ಇಂಜಿನಿಯರ್ ಆಗ್ತಿದ್ರ ಬದಲು ಲಾಯರ್ ಆಗಿ ಈಗ ಒಳ್ಳೊಳ್ಳೆ ಕಂಪ್ನಿಗಳಲ್ಲಿ ನಮಗೆ ಕ್ಯಾಂಪಸ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ ಅಂತ 3rd year 4th yearಗೆ ಅವರು ಮಾರ್ಕ್ಸ್ ತೊಗೊಂಡ್ಬಿಟ್ಟು ಅಲ್ಲೆಲ್ಲೇ ಗುರ್ತಿಸ್ಕೊಂಡು ಸ್ಟೇಜ್ಗೆ ಹೋದರೆ, ಆರ್ ವಿ ಪ್ರಿಪೇರಿಂಗ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಆರ್ ಕ್ಲರ್ಕ್ಸ್ ಫಾರ್ ದಿ ಕಂಪನೀಸ್? ಅಡ್ವೊಕೇಟ್ಸ್ ಆಗ್ಬೇಕಂದ್ರೆ ದಿ ಮಸ್ಟ್ ಟೇಕ್ ಅಪ್ ದಿ ಚಾಲೆಂಜಸ್. ಕೋರ್ಟ್ ಮುಂದೆ ಜಡ್ಜ್ ಮುಂದೆ ಬಂದು ನಿಂತ್ಕೊಂಡ್ರೆ ವಿಲ್ ಬಿ ಕಾಲ್ಡ್ ಆಸ್ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ಮೇ ಬಿ ಕಾಲ್ಡ್ ಆಸ್ ಅಡ್ವೊಕೇಟ್. ಎಲ್ಲೋ ಕೂತ್ಕೊಂಡು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್ ಕೆಲಸ, ತಾಲೂಕು ಆಫೀಸ್ ಕೆಲಸ, ಇನ್ನೊಂದು ಕೆಲಸ ಮಾಡಕ್ಕೆ ನಾನು ನ್ಯಾಷನಲ್ ಲಾ ಸ್ಕೂಲಲ್ಲಿ ಹೋದೆ, ಈಶ್ವರ್ ಭಟ್ ಸ್ಟೂಡೆಂಟ್ ಆಗಿದ್ದರಿಂದ ಯೂನಿವರ್ಸಿಟಿ ಗೌರವ ಏನಿರುತ್ತೆ. ಹಾಗಾಗಿ ವಿ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಸಮ್ ಸೆಗ್ರಿಗೇಷನ್, ಸಮ್ ಐಡೆಂಟಿಫಿಕೇಶನ್ಸ್, ವಿ ಹ್ಯಾವ್ ಟು ಬೈಫೋಕೇಟ್ ಥಿಂಗ್ಸ್. ನಿಜವಾಗಿ ಇಂಟ್ರೆಸ್ಟ್ ಯಾರಿಗಿದೆ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಒತ್ತು ಕೊಟ್ಟು ನಾವು ಪ್ರೊಫೆಷನ್ಗೆ ಬರಂಗೆ ಮಾಡೋದು ಸರಿ ಅನ್ಸುತ್ತೆ. ಡಿಗ್ರೀಸ್ ಹೇಗೆ ಬಂದು ತಗೊಳ್ಳಿ, ಪಾಪ ಅವ್ರು ಮಾಡಬಾರ್ದಲ್ಲ. ನಾವು ಸುಮ್ಮನೆ ವೇಸ್ಟ್ ಆಫ್ ಅವ್ರ ಎಫರ್ಟ್ಸನ್ನು ಮಾಡೋದು. ಯಾಕಂದರೆ ಮೇಡಮ್ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ದಕ್ಕೆ ನಾನು ಮಾತಾಡ್ತೀನಿ. 6 ವರ್ಷ ಮಾಡಿ 1 ವರ್ಷ ಕೋರ್ಟ್ಗೆ ಹೋಗೋದ್ರೆ ದೇ ಮೇ ಪ್ರೊಟೆಸ್ಟ್, ನಮಗೇನು ಬೇಕು, ನಮ್ಗೆ ಅದು ಬೇಕಾಗಲ್ಲ, ನಾನು ಐ ವಿಲ್ ಜಾಯಿನ್ ಕಂಪನೀಸ್, ಐ ವಿಲ್ ಗೋ ಅಬ್ರಾಡ್, ಹೀಗೇನಾದ್ರು ಹೇಳ್ಬೋದು. ವಿಲ್ ಗಿವ್ ದ ಆಪ್ಷನ್, ಅವ್ರು ಇಷ್ಟ ಅದು. ಪ್ರಾಕ್ಟೀಸ್ ಕಡ್ಡಾಯವಾಗಿ ಮಾಡ್ತೀನಿ ಇನ್ನೊಂದು 6 ವರ್ಷ ಇರಬೇಕಂತ ಮಾಡಿದ್ರೆ ಖಂಡಿತ ತಗೋಲ್ಲ. ಇಫ್ ಯು ವಾಂಟ್ಸ್ ಟು ಜಾಯಿನ್ ಪ್ರೊಫೆಷನ್, ಮಾಡಪ್ಪ 6 years, ಅದರ್ವೈಸ್ ಯು ಕೀಪ್ ಯುವರ್ ಬಿಸ್ನೆಸ್ ಅಂಡ್ ಗೋ ಫಾರ್ 5 years. ನಮಗೇನು ಆಗಬೇಕಾಗಿಲ್ಲ ಅಂತ. ಈಗ ಏನಾದರೂ ಸುಧಾರಣೆ ತರಬೇಕು, ಮಾತಾಡ್ತಾ ಹೋದರೆ ಭಾಳ ಮಾತಾಡ್ಬೋದು. ನಾವು ಹಾಗಾಗಿ ಕೂತು ಮಾತಾಡ್ತಿದ್ವಿ, ಎಜುಕೇಷನ್ ಪಾಲಿಸಿಯಿಂದ ಹಿಡಿದು ಇಲ್ಲಿವರೆಗೆ ಮಾತಾಡ್ತಾ ಬಂದಿದ್ದೀವಿ. ಬಟ್ ನಂದು ಒಂದೇ ಒಂದು ಭಾವನೆ, ಈ ಯೂನಿವರ್ಸಿಟಿಗೆ ಭಾಳ ಗೌರವ ಬರುವಾಗ ನಾವು ನಡ್ಕೋಬೇಕು. ಯಾಕೆಂದರೆ ಅವ್ರ ಫಾದರ್ ಹೇಳಿದ್ರು, ಓನ್ಲಿ 3 colleges, ಪೂನಾ, ಬೆಳಗಾಂ, ಚೆನ್ನೈ. ಅವತ್ತು ಲಾ ಕಾಲೇಜ್ ಇದ್ದಿದ್ದು. ಅನಿವಾರ್ಯ ಪೂನಾಗೆ ಸೇರಿದವರು ಆಮೇಲೆ ಬೆಳಗಾಮಿಗೆ ಬಂದಿರ್ತಾರೆ. ಬೆಳಗಾಂ ಬಿಟ್ಟರೆ ಓದಬೇಕಾಗಿದ್ದು ಚೆನ್ನೈಯಲ್ಲೇ ಲಾನ. ಮಧ್ಯೆ ಇಡೀ ದೇಶ ಬ್ಲ್ಯಾಂಕ್ ಇತ್ತು. ಹಾಗಾಗಿ ವಿ ಆರ್ ಕರ್ಸ್ಡ್ ಆನ್ ದೋಸ್ ಡೇಸ್. ಓನ್ಲಿ ಕಾಲೇಜ್ ವಾಸ್ ಇನ್ ಬೆಳಗಾಂ. ಬಿಟ್ಟರೆ ಇಡೀ ರಾಜ್ಯದಲ್ಲಿ ಲಾ ಕಾಲೇಜ್ಗಳು ಇರಲಿಲ್ಲ. ಇಡೀ ಕರ್ನಾಟಕದಲ್ಲಿ ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಷನ್ ಕಾಮರ್ಸ್ ಇರಲಿಲ್ಲ. ನನ್ನ ಸೋದರ ಮಾವ ಕಾಮರ್ಸ್ MCom ಮಾಡಲಿಕ್ಕೆ ಬನಾರಸ್ಗೆ ಹೋಗ್ಬೇಕಾಗಿದ್ದ ಕಾಲ ಇತ್ತು. ಈಗ ಇಷ್ಟೆಲ್ಲ ಫೆಸಿಲಿಟಿ ನಾವು ಕ್ರಿಯೇಟ್ ಮಾಡಿಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಮನೆ ಬಾಗಿಲಲ್ಲಿ ಕಾಲೇಜ್ ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ನಮ್ಗೆ ಅಟೆಂಡೆನ್ಸ್ ಕೇಳಬೇಡಿ, ನಮಗೆ ಪರೀಕ್ಷೆ ಮಾಡಬೇಡಿ ಅನ್ನೋದು ಬಿಟ್ಟು ನಾವು ಓದಬೇಕಂದ್ರೆ ನಿಮ್ಗೆ ಏನೇನು ಬೇಕೋ ಮಾಡೋಕ್ಕೆ ಸರ್ಕಾರ ಇದೆ, ಯೂನಿವರ್ಸಿಟಿ ಇದೆ ಅಂದರೆ ಆ ದಿಕ್ಕಿಗೆ ಬರ್ತಾ ಇಲ್ಲ ಮಕ್ಕಳು ಅಂದರೆ ಸ್ವಲ್ಪ ನೋವಾಗುತ್ತೆ. ನಂದು ಹೇಳಿದೆ ಬಂದಾಗ ಸ್ವಲ್ಪ ನಾನು ಹೊರಟಾಗಿ ಬಂದಿದ್ದೀನಿ ಇವತ್ತು ಮಾತಾಡೋಕ್ಕೆ. ಏಕೆಂದರೆ ಎಲ್ಲ ಒಂದು ಕಡೆ ಸರಿನಾ ಅಂತ ಫೆಸಿಲಿಟೀಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾ ಲೈಫ್ನ ಭಾಳ ಈಸಿಯಾಗಿ ತೊಗೊಂಡು ಹೋಗ್ಬೇಕು. ಎಲ್ಲರಿಗೂ ಪುಕ್ಷತೆ ಮಾರ್ಕ್ಸ್ ಬರಬೇಕು, ಪುಕ್ಷತೆ ನಮಗೆ ಡಿಗ್ರಿ ಈ ಕಾನ್ವೆಂಟಲ್ಲಿ ಕೊಡ್ತಾರಲ್ಲ A+, A++, A++. ಇದನ್ನೇ ಲಾ ಯೂನಿವರ್ಸಿಟಿನಲ್ಲೂ ನೀವು ಅಂದ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ರೆ ಲಾಯರ್ಸ್ ಆಗಿ ಹೋದ್ರೆ ನಿಮ್ಗೇನು ಆಗ್ಲಾರ್ದು, ಬಟ್ ನಮ್ದವ್ರ ಗತಿ ಏನು ಅನ್ನೋದು ಅಷ್ಟೇ ನಮ್ಮ ಚಿಂತೆ. ಅವ್ರೇನಾಗ್ಬೇಕಪ್ಪ ನಾಳೆ ನಿಮ್ಮ ಕಡೆ ಎಲ್ಲ ಇಡೀ ಹಣೆ ಬರೋಣ ಭವಿಷ್ಯನ ಕೈಲಿ ಕೊಟ್ಬಿಟ್ಟು ನಿಮ್ಮ ಭಾಷೆ ಅವನಿಗೆ ಬರಲ್ಲ, ಮಾತಾಡ್ದ ನಮ್ಮ ಲಾಯರ್ ಇಂಗ್ಲೀಷ್ನಲ್ಲಿ ಅರ್ಧ ಗಂಟೆ ಅಂತ ಬಿಟ್ರೆ ಏನ್ ಮಾತಾಡೋದು ಗೊತ್ತಿಲ್ಲ ಅಂತ ನಾನು. ಆ ಸ್ಥಿತಿಲಿ ನಾವಿರುವಾಗ ಹೇಗಾರು ಮಾಡಿ ಸ್ವಲ್ಪ ಓದ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಡೀಪ್ ಇಂಟ್ರೆಸ್ಟ್ ತಗೊಳ್ಳಿ. ನೀವು ಯಾರು ಅರ್ಥ ಮಾಡ್ಕೊಂಡು ಓದ್ತೀರಾ ಬದುಕಲ್ಲಿ ನಿಮಗೆ ಅಗರ ಆಗುತ್ತೆ, ಜೀವನ ಪ್ರೊಫೆಷನ್ ಅಗರ ಆಗುತ್ತೆ. ಪರೀಕ್ಷೆಗೋಸ್ಕರ ಓದಿದ್ರೆ ಆಗೋದಿಲ್ಲ. 10 ಮಾರ್ಕ್ 10 ಓದೋದು, 6 ಬಂದರೆ ಫಸ್ಟ್ ಕ್ಲಾಸು, 5 ಬಂದರೆ ಸೆಕೆಂಡ್ ಕ್ಲಾಸು, 4 ಬಂದು ಸರ್ ಬರೀ ಪಾಸ್ ಕ್ಲಾಸು ಅನ್ನೋ ಸ್ಥಿತಿಗೆ ನಾವು ಬರಬಾರ್ದು. ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ರೀಡಿಂಗ್ ಬಿಟ್ವೀನ್ ವರ್ಡ್ಸ್. ಲಾ ನೀಡ್ಸ್ ಅಂಡ್ ರಿಕ್ವೈರ್ಸ್ ರೀಡಿಂಗ್ ಬಿಟ್ವೀನ್ ವರ್ಡ್ಸ್. ನಮ್ಗೆ ಗೊತ್ತು ಆ ಕಷ್ಟ. ಲೆಜಿಸ್ಲೇಷನ್, ನನ್ಗೆ ಇನ್ನೊಂದು ಖಾತೆ ಇದೆ ಲೆಜಿಸ್ಲೇಷನ್ ಅಂತ, ಪಾರ್ಲಿಮೆಂಟರಿ ಅಫೇರ್ಸ್ ಅಂಡ್ ಲೆಜಿಸ್ಲೇಷನ್ ಮಾಡುವಾಗ ನಮ್ಗನ್ಸುತ್ತೆ, ಅನುಭವ ಆಗುತ್ತೆ, ಒಂದೊಂದು ಅಕ್ಷರ ಒಂದೊಂದು ಪದದಲ್ಲಿ ಎಷ್ಟು ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ ಅಂತ. ಇಟ್ಸ್ ಆರ್ ಬೈ ಅನ್ನೋ ಪದಕ್ಕೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಂಟ್ ಅಸೆಂಬ್ಲಿ 1 ದಿವಸ ಡಿಬೇಟ್ ಆಗಿದೆ. ಒಂದ್ ಕಡೆ ಬೈ ಅಂತ ಪದ ಸೇರಿಸ್ಬೇಕಾ, ಇಟ್ಸ್ ಅಂತ ಪದ ಸೇರಿಸ್ಬೇಕಾ ಅಂತ ಒನ್ ಡೇ ದಿ ಹೋಲ್ ಡಿಬೇಟ್ ಆಗುತ್ತೆ. ಅದು ಯಾರು ಅಂಬೇಡ್ಕರ್ ಇದ್ದಂತ ಕಾನ್ಸ್ಟಿಟ್ಯೂಂಟ್ ಅಸೆಂಬ್ಲಿ. ಹಾಗೆ ಇಫ್ ಯು ಕೀಪ್ ಆನ್ ಡಿಬೇಟಿಂಗ್ ಥಿಂಗ್ಸ್, ಒಂದೊಂದು ಪದ ಈ ಪ್ರೊಫೆಷನಲ್ಲಿ, ಈ ಕೋರ್ಸಲ್ಲಿ ಮತ್ತೆ ಈ ಫ್ರೆಟರ್ನಿಟಿನಲ್ಲಿ ಬೇಕಾದಷ್ಟು ವ್ಯತ್ಯಾಸಗಳನ್ನ ಸೃಷ್ಟಿ ಮಾಡಿಬಿಟ್ಬಿಡುತ್ತೆ, ಹಣೆ ಬರಗಳನ್ನೇ ಬದಲಾಯಿಸುತ್ತೆ. ಪ್ರತಿ ಪದ ಹೇಳ್ಬೇಕು ಕೇಳಿ ನಮ್ಮ ಲಾ ಸೆಕ್ರೆಟರಿ ಕೂತೂರೆಲ್ಲ ಸುಸ್ತಾಗ್ಬಿಟ್ಟವ್ ನನ್ನ ಹತ್ರ. ಹೈಕೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಸಾಕಂತ ನಮ್ಮ ವೆಂಕಟೇಶ್ ನಾಯ್ಕ. ಏಕೆಂದ್ರೆ ಎವ್ರಿ ಡೇ ವಿ ಸಿಟ್, ಎವ್ರಿ ಡೇ ವಿ ಡಿಸ್ಕಸ್. ಒಂದೊಂದು ಅಕ್ಷರಕ್ಕೆ ಒಂದೊಂದು ಪದಕ್ಕೆ ಎಷ್ಟೆಷ್ಟು ವ್ಯತ್ಯಾಸ ಬರುತ್ತೆ ಅನ್ನೋದನ್ನ ಲಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ಎಷ್ಟು ಕಷ್ಟಪಡ್ತೀವಿ ಅಂದ್ರೆ ಅದು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಬೇಕು. ದೆನ್ ಓನ್ಲಿ ಯು ವಿಲ್ ಬಿಕಮ್ ಗುಡ್ ಲಾಯರ್ಸ್. ಅದು ಅರ್ಥ ಆಗ್ಬಿಟ್ರೆ ಒಳ್ಳೆ ಲಾಯರ್ಗಳಾಗ್ತೀರಿ. ಸೊ ಕೀಪ್ ರೀಡಿಂಗ್, ಟ್ರೈ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಯು ರೀಡ್. ಓದೋದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೋದೆ ಹೋದ್ರೆ ಅದು ವಿದ್ಯೆನೇ ಅಲ್ಲ, ವಿದ್ಯೆನೇ ಅಲ್ಲ. ಮತ್ತು ನಮ್ಮಲ್ಲಿರೋಷ್ಟು ಎಲಾಸ್ಟಿಸಿಟಿ, ನಾವು ಎಳೆದಂಗೆ ಎಳಿಬೋದಾಗಿರೋ ಒಂದು ಕೋರ್ಸ್ ಅಂದ್ರೆ ಇದೇನೆ. ಜಸ್ಟಿಸ್ ರವೀಂದ್ರನು ನಾವು ಒಂದು ಯಾವುದೋ ಸಭೆಯಲ್ಲಿ ಸೇರಿದ್ದು, ಯಾವುದೋ ಒಂದು ಸಣ್ಣನ ಉದಾಹರಿಸ್ಬಿಟ್ಟು ಅವ್ರು ಹೇಳಿದ್ರು, ಯಾವುದೋ ಒಂದು ಲೇಡಿ ಹೋಗ್ತಿರ್ತಾಳೆ ಇಲಾಜಿ ಅಲ್ವಾಗಿ, ವಿಶ್ ಮಾಡ್ತಾಳೆ, ಹುಡುಗರು ಯಾರೋ ಬರ್ತಾರೆ 2-3 ಜನ ಜೊತೆ ಇದ್ರೆ, ಬೆಳಗ್ಗೆ ಅವಳು ಬಂದ್ಬಿಟ್ಟು ನನಗೆ ರೇಪ್ ಆಯ್ತು, ಗ್ಯಾಂಗ್ ರೇಪ್ ಅಂತ ಕೇಸ್ ಕೊಡ್ತಾಳೆ ಮಾಧುಸ್ವಾಮಿ ಅವರೇ. ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ ಹೋಗ್ಬಿಡುತ್ತೆ. ಕನ್ಸೆಕ್ಷುವಲ್ ಸೆಕ್ಸ್ ಅಂತ ಹೇಳಿ ಇಬ್ರು ಜಡ್ಜ್ ಹೇಳ್ತಾರೆ, ರೇಪ್ ಅಂತ ಹೇಳಿ ಇಬ್ರು ಜಡ್ಜ್ ಹೇಳ್ತಾರೆ, ಒಬ್ರು ನ್ಯೂಟ್ರಲ್ ಅಂತಾರೆ. ಕಾನೂನದೇ, ಆ ಹೆಣ್ಮಗಳದೇ, ಆ ರೇಪಿಸ್ಟ್ ಅವರೇ, ಜಡ್ಜ್ಮೆಂಟ್ 3 ಬರ್ತಾವ ಗಣಪ ಈ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಅಂದ್ರು. ನಾನು ಅಂದಿದ್ರೆ ದೊಡ್ಡ ತಪ್ಪಾಗೋದು. ರವೀಂದ್ರ ನೀವ್ ಅಂದಿದ್ದಕ್ಕೆ ಸರಿಯಾಗಿದೆ ಸರ್, ನಾವು ಅಂದ್ಬಿಟ್ಟಿದ್ರೆ ಅವ್ರು ಸ್ಟ್ರಾಂಗ್ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡ್ಬಿಡೋರು. ಅವ್ರು ಹೇಳಿದ್ರು 5 ಜನ ಬರೆದ್ರೆ 5 ರೀತಿ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ತವೆ. ಹಳ್ಳಿಯವ್ರಿಗೆ ಹೆಂಗಪ್ಪ ಅರ್ಥ ಆಗುತ್ತೆ ನ್ಯಾಯ ಅಂದ್ರೇನು, ಕಾನೂನು ಅಂದ್ರೇನು, ಹೇಗೆ ಅರ್ಥ ಆಗಬೇಕು ಅಂತ. ಇದು ಅರ್ಥ ಆಗಬೇಕಂದ್ರೆ ವಿ ಹ್ಯಾವ್ ಟು ರೀಡ್ ಬಿಟ್ವೀನ್ ವರ್ಡ್ಸ್ ಅಂಡ್ ಸೆಂಟೆನ್ಸಸ್. ಸ್ವಲ್ಪ ಶ್ರಮ ತಗೊಂಡೋದ್ರಿ. ಕಷ್ಟಪಟ್ಟು ಇಲ್ಲಿ ಕಾಲೇಜ್ ಆಗಿದೆ, ಇಲ್ಲಿ ಬಹಳ ಕಷ್ಟಪಟ್ಟು ಯೂನಿವರ್ಸಿಟಿ ಆಗಿದೆ. ನನ್ನ ಮೇಲೆ ಬಹಳ ಒತ್ತಡ ಇದೆ. ಅಟಾನಮಿ ಡಿಕ್ಲೇರ್ ಮಾಡಿ, ಡೀಮ್ಡ್ ಯೂನಿವರ್ಸಿಟಿಗಳು ಮಾಡಿ, KSLU ಸೊಸೈಟಿ ಅವ್ರದ್ದು ಒತ್ತಡ ಇದೆ. ಬೆಂಗಳೂರಿನಲ್ಲಿರೋರೆಲ್ಲ ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ ಕಾಲೇಜಸ್ ವಾಟ್ಸ್ ದೇರ್ ಅಟಾನಮಿ. ಬೇಕಾಗಿಲ್ಲ, ಎಕ್ಸಾಮಿನೇಷನ್ಸ್ ಆಗ್ತಾ ಇಲ್ಲ, ಸಿಸ್ಟಮ್ ಸರಿಗಿಲ್ಲ. ನೀವೇನಾದ್ರು ಝೋನಲ್ ಆಫೀಸಸ್ ಮಾಡಿದ್ರೆ ಒನ್ ಡೇ ದೇ ವಿಲ್ ಬಿಕಮ್ ಯೂನಿವರ್ಸಿಟೀಸ್. ಟೇಕ್ ಇಟ್ ಯು. ಇವತ್ತು ಯಾವ್ಯಾವುದು ಝೋನಲ್ ಆಫೀಸಸ್ನ ಯೂನಿವರ್ಸಿಟಿಗಳಿಗೆ ಮಾಡಿದ್ವಿ, ನಾವು ವಿ ಹ್ಯಾವ್ ಮೇಡ್ ದೆಮ್ ಆಸ್ ಯೂನಿವರ್ಸಿಟೀಸ್. ಮೈಸೂರು ಝೋನಲ್ ಆಫೀಸ್ ಮಂಡ್ಯ ಇತ್ತು, ಯೂನಿವರ್ಸಿಟಿ ಆಗ್ತಾ ಇದೆ. ಮೈಸೂರು ಸಿಟಿ ಝೋನಲ್ ಆಫೀಸ್ ಹಾಸನ ಇತ್ತು, ಯೂನಿವರ್ಸಿಟಿ ಆಗ್ತಿದೆ. ಇಲ್ಲೂ ಒಂದು ಕೂಗು ಸ್ಟಾರ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ದಟ್ ರೀಜನಲ್ ಆಫೀಸ್ ಆರ್ ಝೋನಲ್ ಆಫೀಸ್ನ ಯು ಕ್ಯಾನ್ ನಾಟ್ ಇಟ್ ಆಸ್ ಝೋನ್ ಯೂನಿವರ್ಸಿಟಿ. ಅಲ್ಲೆಲ್ಲ ಅಡಿಕ್ವೇಟ್ ಸ್ಟಾಫ್ ಆಗ್ಲೇ ಇದೆ, ಇನ್ನೊಂದು 4-5 ಜನ ಟೀಚಿಂಗ್ ಸ್ಟಾಫ್ ಹಾಕ್ಬಿಟ್ರೆ ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಬಿ ಆನ್ಲೈನ್ ಅಂತ. ಹಾಗಾಗಿ ಯೂನಿವರ್ಸಿಟಿನ ನೀವೇನಾದರೂ ಮತ್ತೆ ಡಿವೈಡ್ ಮಾಡಬೇಕು, ಸ್ಪ್ಲಿಟ್ ಮಾಡಬೇಕಂದ್ರೆ ಆ ಆಲೋಚನೆಗಳನ್ನ ಮಾಡಿ. ನೀವು ಆಲೋಚನೆ ಮಾಡೋಕೆ ಒಂದು 8 ದಿವಸ ಮೊದಲೇ ನಂಗೆ ಹೇಳಿಬಿಟ್ರೆ ನಾನೊಂದು 10 ಕಾಲೇಜ್ನ ಅಟಾನಮಸ್ ಮಾಡಿಬಿಟ್ಟು ಕೈ ಬಿಟ್ಬಿಡ್ತೀನಿ. ಅವ್ರು ಹೇಗಾರು ಬದುಕೊಳ್ಳಿ, ಅವ್ರ ಪಡ್ಬೋದು, ಚೆನ್ನಾಗಿರೋ ಕಾಲೇಜ್ನವ್ರು, ನಿಮ್ಮ ಹತ್ರ ಬೇಡ. ಬಟ್ ರೀಜನಲೈಸೇಷನ್ ಮಾಡಬೇಕಾ ಬೇಡ? ನಾವು ಭಾಳ ಹಠ ಮಾಡಿ ಒಂದೇ ಒಂದು ಲಾ ಕಾಲೇಜ್ ಪ್ರೈವೇಟ್ ಸೆಕ್ಟರ್ ಬರೋಕ್ಕೆ ನಾನು ಮಿನಿಸ್ಟರ್ ಆದ್ಮೇಲೆ ಬಿಟ್ಟಿಲ್ಲ. ಐ ಆಮ್ ಹ್ಯಾಪಿ ಟು ಸೇ No. No. Take the affiliation from Law University, then only. ಸ್ಪಷ್ಟವಾಗಿದ್ದೀವಿ ನಾವು. ಇದೇನಾದ್ರು ಸ್ವಲ್ಪ ಬಿಟ್ಬಿಟ್ರೆ ನಾಯಿ ಕೂಡ ಆಗ್ಬಿಡುತ್ತೆ. ಇಟ್ ವಿಲ್ ಬಿಕಮ್ ಮೋಸ್ಟ್ ಕಮರ್ಷಿಯಲ್ ಆಕ್ಟಿವಿಟಿ ಇನ್ ಫ್ಯೂಚರ್. ನಿಮ್ಗೆ ಹೇಳಿರ್ತೀನಿ, ಮೆಡಿಕಲ್ಗಿಂತ ಲಾ ಪ್ರೊಫೆಷನ್ಗೆ ಜಾಸ್ತಿ ಡಿಮ್ಯಾಂಡ್ ಬರುತ್ತೆ, ದುಡ್ಡು ಕೊಟ್ಟು ಓದಬೇಕಾಗತ್ತೆ. ಬಿಕಾಸ್ ನಮ್ಮ ಟಾರ್ಗೆಟ್ ಇತ್ತು 1000 ಪಾಪ್ಯುಲೇಷನ್ಗೆ ಒಬ್ಬ ಡಾಕ್ಟರ್ ಬೇಕಂತ. ಯು ವಿಲ್ ಬಿ ಶಾಕ್ ಟು ನೋ ವಿ ಹ್ಯಾವ್ 2 ಡಾಕ್ಟರ್ಸ್ ಫಾರ್ 1000 ಪಾಪ್ಯುಲೇಷನ್ ಟುಡೇ ಇನ್ ಕರ್ನಾಟಕ. ಇಬ್ಬರಿದ್ದಾರೆ ಡಾಕ್ಟ್ರು. ಒಬ್ಬಿಲ್ಲ ಅಂತ ಓದಾಡ್ಕೊಂಡು ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ ಮಾಡಿದಾಗ ಇಬ್ಬರಾಗ ಅವ್ರು ಏನು ಮಾಡೋದು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಮುಂದೆ ಲಾಯರ್ ಒಂದು ಊರಿಗೆ ಇಬ್ಬಿಬ್ರು ಬೇಕಾಗ್ತಾರೆ. ಎಲ್ಲ ಮಾತೆತ್ತಿದ್ರೆ ಲಿಟಿಗೇಷನ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ ನಾವು, ಮತ್ತೆ ಮಾತೆತ್ತಿದ್ರೆ ಒಪಿನಿಯನ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ ನಾವು, ಮಾತೆತ್ತಿದ್ರೆ ಕೌನ್ಸಿಲಿಂಗ್ ಇರ್ತೀವಿ, ಕೌನ್ಸಿಲಿಂಗೇ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ. ಮೀಡಿಯೇಷನ್ ಮಾಡಕ್ ಲಾಯರ್ ಬೇಕು. ಗಂಡ ಹೆಂಡತಿ ಬಿಡ್ಬೇಕಾ ಬೇಡವನ್ನಕ್ ಲಾಯರ್ ಬೇಕು. ಮೀಡಿಯೇಷನ್ ಆಗ್ಲೇಬೇಕಲ್ಲ, ಇವರೇ ಮಾಡ್ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮೀಡಿಯೇಷನ್ ಆಗಬೇಕು 3 ಸ್ಟೇಜು, ಇಲ್ಲ ಅಂಗನವಾಡಿಯವ್ರು ಮಾಡಿ, ಇಲ್ಲ ಪೊಲೀಸ್ನವ್ರು ಮಾಡಿ, ಇಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಮಾಡಿ. ಸೊ ವಿ ನೀಡ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಫಾರ್ ಮೀಡಿಯೇಷನ್, ವಿ ನೀಡ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಫಾರ್ ಕೌನ್ಸಿಲಿಂಗ್, ವಿ ನೀಡ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಟು ಟ್ರಯಲ್ ಕೇಸಸ್. 7 ಜನ ಬೇಕಾಗ್ತಾರೆ. ನೀವು ಮಕ್ಳು ಯೋಚನೆ ಮಾಡ್ರಿ. ಹಾಗಾಗಿ ಒಳ್ಳೆ ಅಡ್ವೊಕೇಟ್ ಆದರೆ ಮೀಡಿಯೇಷನ್ ಮಾಡ್ಕೊಂಡಿರ್ಬೋದು. ಬೇಡ ಇನ್ನೊಂದು 6 ತಿಂಗಳ ಜೊತೆಲಿ ಹೋಗು, ಆಮೇಲೆ ಬಾ ನನಗೊಂದಿಷ್ಟು ಫೀಸ್ ಕೊಡು ಅಂತೆಲ್ಲ ಹೇಳಿ ಕಳಿಸ್ಬೋದು. ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಸೀರಿಯಸ್ ಇನ್ ದಿಸ್ ಪ್ರೊಫೆಷನ್. ನನಗೆ ನೋವಿದೆ, ಲಾ ಪ್ರೊಫೆಷನನ್ನು ಸ್ಟೂಡೆಂಟ್ಸು ಬೇರೆ ತಗೊಂಡ್ರು ಸೀರಿಯಸ್ ತಗೊಂಡಿಲ್ಲ. ಎಂಜಿನಿಯರಿಂಗ್ ಆಗಲಿ ಮೆಡಿಕಲ್ ಕೋರ್ಸ್ ತಗೊಂಡ್ರು ಸೀರಿಯಸ್ ನೀವು ಯಾರು ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಅನಿಸಿದೆ ನನಗೆ. ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಸೀರಿಯಸ್, ಅದರ್ವೈಸ್ ಯು ವಿಲ್ ನಾಟ್ ಸರ್ವೈವ್ ಇನ್ ದಿ ಫೀಲ್ಡ್. ಅಲ್ಲಿ ಹೇಗೋ ಆಗ್ಬಿಡುತ್ತೆ. ಮೆಡಿಕಲ್ ಕೋರ್ಸು ಪ್ರೊಫೆಷನಲ್ಲಿ ಹೇಗೋ ನಡೆದ್ಬಿಡುತ್ತೆ. ಡಾಕ್ಟರ್ ಅಂದರೆ ಅವ್ರಿಗೆ ನಡೆದೋಗುತ್ತೆ. ಇಲ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ಯುವರ್ ಸ್ಟಫ್ ಬಿಫೋರ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಅಂಡ್ ಕೋರ್ಟ್. ಹಾಗಾಗಿ ಕಷ್ಟಪಟ್ಟು ಓದಿ. ಇವತ್ತೇನು ಫೌಂಡೇಶನ್ ಡೇ ಆಗಿದೆ, ಇದರಿಂದ ನಿಮ್ಮ ಭವಿಷ್ಯ ಚೆನ್ನಾಗಲಿ. ಮತ್ತು ಎರಡನೇದು ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ವಿಜ್ಞಾನೇಶ್ವರ ಪೀಠ ಆಯ್ತು. ಎಸ್, ಅವ್ರು ಹೇಳಿದಾಗ ನಾನು ಭಾಳ ಸಪೋರ್ಟ್ ಕೊಟ್ಟು ಗೌರ್ಮೆಂಟಿಂದ 1 ಕೋಟಿ ರಿಲೀಸ್ ಮಾಡಿಸಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪೀಠ ಇಲ್ಲಿ ಮಾಡಿ ಚರ್ಚ್ಗಳಾಗಲಿ. ಹಾಗೇನೆ ನೀವು ಇವತ್ತೇನು ಅನೌನ್ಸ್ ಮಾಡಿದ್ರಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಮಾಡಿ, ನಾನು CM ಕಡೆಯಿಂದ 50 ಲಕ್ಷ ಕೊಡಿಸ್ತೀನಿ, ನೀವು 50 ಲಕ್ಷ ಮಾಡ್ಕೊಂಡು ಮಾಡಿ. ನೀವು ಸಿಂಡಿಕೇಟ್ ರೆಸಲ್ಯೂಷನ್ ಗೌರ್ಮೆಂಟ್ ಫಂಡ್ ಬೇಕಾದಿದ್ದೀರಿ, ನೀಡ್ ನಾಟ್. ನಾನು ಬೊಮ್ಮ ಅವ್ರಿಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದೀನಿ, ನಿಮ್ಮ ತಂದೆಯವರ ಹೆಸರು ಬೆಂಚ್ ಮಾಡ್ತಾ ಇದ್ದೀವಪ್ಪ, ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ 50 lakhs ಪರ್ಸನಲ್ ಮನಿ. ಆ್ಯಂಡ್ he has agreed. ನಾನು ಮಾತಾಡೋದು ಕೇಳಿದ್ದೀನಪ್ಪ, ನಾಳೆ ನಾನು ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರು 50 ಲಕ್ಷ ನಿಮಗೆ ದುಡ್ಡು ಕೊಡ್ತಾರೆ, ಯೂನಿವರ್ಸಿಟಿಯಿಂದ ಒಂದು 50 ಲಕ್ಷ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿಕೊಂಡು ಬೊಮ್ಮ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಮಾಡಿ. ಯಾಕೆಂದರೆ ನಿನ್ನೆ ನಾವು ಯಾವುದಾದ್ರೂ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೇಸ್ ರಾಜಕೀಯದವ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟರೆ SR ಬೊಮ್ಮಾಯಿ ಕೇಸ್ ಅಂತಲೇ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇದ್ವಿ ನಾವು. SR ಬೊಮ್ಮಾಯಿ ಕೇಸ್ ಅಷ್ಟೊಂದು ಪಾಪ್ಯುಲರ್ ಇದೆ ನಮ್ಮ ಕೋರ್ಟ್ಗಳಲ್ಲಿ. ಹಾಗಾಗಿ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಕೂಡ ಒಂದು ಮಾಡೋದಾದರೆ ನಾವು ಎಲ್ಲ ರೀತಿ ಸಹಕಾರನ ನಿಮಗೆ ಕೊಡಿಸ್ತೀವಿ. ನೀವು ಯಾವಾಗ ಬರ್ತೀರಿ ಆಗ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಫ್ಯಾಮಿಲಿ ಶೇರ್ ಏನಿದೆ ಅವ್ರ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ನಾನು ಕೊಡಿಸ್ತೀನಿ. ದಯವಿಟ್ಟು ಆರ್ಗನೈಸ್ ಮಾಡಿ. ಇದಕ್ಕೆಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಮುಂದೆ ಹೋಗಿ ಕೂತ್ಕೊಳ್ಳೋದೇನು ಅಗತ್ಯ ಇರೋದಿಲ್ಲ. ವಿ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ಸಮಥಿಂಗ್ ಆನ್ ಅವರ್ ಓನ್. ಈಗೇನಾದ್ರು ಮಾಡಿಕೊಂಡು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮಾಡಿ ಪುಲಪ್ ಮಾಡಿ. ಮತ್ತು ಡಿಜಿಟಲೈಸೇಷನ್ ಆಫ್ ಲೈಬ್ರರೀಸ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್. ಮಕ್ಕಳಿಗೆ ಡಿಜಿಟಲೈಸ್ ಮಾಡಬೇಕು. ಒಂದು ನಾನು ಸನ್ಮಾನ್ಯ ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗಿದ್ವಿ. ನಾವು ಹೇಳಿದ್ವಿ ಆಪ್ ಡೆವಲಪ್ ಮಾಡಿ, ಬರೀ ಡಿಜಿಟಲೈಸ್ ಮಾಡೋದು ಬೇಡ, ಮೊಬೈಲ್ ಆಪ್ ಕೂಡ ಕೊಟ್ಬಿಟ್ಟು ಮಕ್ಕಳಿಗೆ ಏನಾದ್ರು ಅದನ್ನು ಆ್ಯಪಲ್ಲಿ ಇಟ್ಕೊಂಡು ಓದೋವಂಥ ಸ್ಟೇಜ್ಗಾರ ತರಬೇಕು. ರೆಫರೆನ್ಸಸ್ಸು, ಬಹಳ ಬುಕ್ಸು, ಕೇಸಸ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸಸ್, ಹೈಕೋರ್ಟ್ ಕೇಸಸ್ ಎಲ್ಲ ಆ್ಯಪಲ್ಲೇ ನಾವು ಬರುವಂಥ ಸ್ಥಿತಿನ ನಿರ್ಮಾಣ ಮಾಡಬೇಕು. ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡು ನೋಡುವಂಥ ಸ್ಟೇಜ್ ಅಂತೇಳಿ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಇಟ್ ಗೋಸ್, ಇಟ್ಸ್ ವಂಡರ್ಫುಲ್. ಮತ್ತು ನಾವು SC/ST ಮಕ್ಕಳಿಗೆ ಎಲ್ಲೋ ಒಂದು ಕಡೆ ನಾವು ಸ್ಟೈಫಂಡ್ ನಿಲ್ಲಿಸಿದ್ದನ್ನೆಲ್ಲ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀವಿ. ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಅಪ್ ದಿ ಕೋರ್ಸ್ ಸೀರಿಯಸ್ಲಿ. ಹಾಗಿದ್ದಾಗ ಮಾತ್ರ ಯೂನಿವರ್ಸಿಟಿ ಇವತ್ತೇನು ಸೆಲೆಬ್ರೇಟ್ ಮಾಡ್ತಿದ್ವಿ ಫೌಂಡೇಶನ್ ಡೇ, ಅದಕ್ಕೆ ಗೌರವ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಮೇಡಮ್ ಅವ್ರಿಗೆ ನಾನು ನಿಜವಾಗ್ಲೂ ಆಭಾರಿ. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅಲ್ಲಿಂದ ಬಂದಿದ್ದಾರೆ. ಯಾಕೆಂದರೆ ನಾವು ಕಾಯ್ತಾ ಇದ್ದೀವಿ, ಫಾದರ್ ಆಯ್ತು, ಇವರೇ ಅವತ್ತು CJ ಆಗ್ತಾರೆ. ನಮ್ಮವರು ಇವನಲ್ಲಿರೋದ್ರಿಂದ ಅವ್ರಿಗೆ ಒಳ್ಳೇದಾಗಲಿ, ಕರ್ನಾಟಕಕ್ಕೆ ಭಾಳ ಗೌರವ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಅವ್ರು ಬಂದು ನಿಮಗೆಲ್ಲ ನಿಮ್ಮ ಮುಂದಿನ ಶೈಕ್ಷಣಿಕ ದಾರಿನ ಹೇಗೆ ಮಾಡ್ಬೋದು ಅಂತೇಳಿ ಅಡ್ವೈಸ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಭಾಳ ಆಭಾರಿ ಅಂತೇಳಿ ಈ ಯೂನಿವರ್ಸಿಟಿ ಪ್ರೋತ್ಸಾಹಿಸಲಾದ ಜವಾಬ್ದಾರಿಯಿಂದ ನಾನು ಅವರಿಗೆ ಅಭಿನಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ. ಸೀರಿಯಸ್ ನೀವು ಯಾರು ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಅನಿಸಿದೆ ನನಗೆ. ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಬಿ ಸೀರಿಯಸ್, ಅದರ್ವೈಸ್ ಯು ವಿಲ್ ನಾಟ್ ಸರ್ವೈವ್ ಇನ್ ದಿ ಫೀಲ್ಡ್. ಅಲ್ಲಿ ಹೇಗೋ ಆಗ್ಬಿಡುತ್ತೆ. ಮೆಡಿಕಲ್ ಕೋರ್ಸು ಪ್ರೊಫೆಷನಲ್ಲಿ ಹೇಗೋ ನಡೆದ್ಬಿಡುತ್ತೆ. ಡಾಕ್ಟ್ರ್ ಅಂದರೆ ಅವ್ರಿಗೆ ನಡೆದೋಗುತ್ತೆ. ಇಲ್ಲಿ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ಯುವರ್ ಸ್ಟಫ್ ಬಿಫೋರ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಅಂಡ್ ಕೋರ್ಟ್. ಹಾಗಾಗಿ ಕಷ್ಟಪಟ್ಟು ಓದಿ. ಇವತ್ತೇನು ಫೌಂಡೇಶನ್ ಡೇ ಆಗಿದೆ, ಇದರಿಂದ ನಿಮ್ಮ ಭವಿಷ್ಯ ಚೆನ್ನಾಗಲಿ. ಮತ್ತು ಎರಡನೇದು ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ವಿಜ್ಞಾನೇಶ್ವರ ಪೀಠ ಆಯ್ತು. ಎಸ್, ಅವ್ರು ಹೇಳಿದಾಗ ನಾನು ಭಾಳ ಸಪೋರ್ಟ್ ಕೊಟ್ಟು ಗೌರ್ಮೆಂಟಿಂದ ಒಂದು ಕೋರ್ಟ್ ರಿಲೀಸ್ ಮಾಡಿಸಿ ವಿಜ್ಞಾನೇಶ್ವರ ಪೀಠ ಇಲ್ಲಿ ಮಾಡಿ ಚರ್ಚ್ಗಳಾಗಲಿ. ಹಾಗೆಯೇ ನೀವು ಇವತ್ತೇನು ಅನೌನ್ಸ್ ಮಾಡಿದಿರಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಮಾಡಿ. ನಾನು CM ಕಡೆಯಿಂದ 50 ಲಕ್ಷ ಕೊಡಿಸ್ತೀನಿ, ನೀವು 50 ಲಕ್ಷ ಮಾಡ್ಕೊಂಬಾಡಿ. ನೀವು ಸಿಂಡಿಕೇಟ್ ರೆಸಲ್ಯೂಷನ್ ಗೌರ್ಮೆಂಟ್ ಫಂಡ್ ಬೇಕಾದಿದ್ದೀರಿ, ನೀಡ್ ನಾಟ್. ನಾನು ಬೊಮ್ಮ ಅವ್ರಿಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದೀನಿ, ನಿಮ್ಮ ತಂದೆಯವ್ರ ಹೆಸರು ಬೆಂಚ್ ಮಾಡ್ತಾ ಇದ್ದೀವಪ್ಪ, ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ 50 lakhs ಯುವರ್ ಪರ್ಸನಲ್ ಮನಿ. ಆ್ಯಂಡ್ he has agreed. ನಾನು ಮಾತಾಡೋದು ಕೇಳಿದ್ದೀನಪ್ಪ, ನಾಳೆ ನಾನು ಹೇಳ್ಬಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರು 50 ಲಕ್ಷ ನಿಮಗೆ ದುಡ್ಡು ಕೊಡ್ತಾರೆ, ಯೂನಿವರ್ಸಿಟಿಯಿಂದ ಒಂದು 50 ಲಕ್ಷ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿಕೊಂಡು ಬೊಮ್ಮ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಮಾಡಿ. ಯಾಕೆಂದರೆ ನಿನ್ನೆ ನಾವು ಯಾವುದಾದ್ರೂ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಕೇಸ್ ರಾಜಕೀಯದವ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟರೆ SR ಬೊಮ್ಮಾಯಿ ಕೇಸ್ ಅಂತಲೇ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇದ್ವಿ ನಾವು. SR ಬೊಮ್ಮಾಯಿ ಕೇಸ್ ಅಷ್ಟೊಂದು ಪಾಪ್ಯುಲರ್ ಇದೆ ನಮ್ಮ ಕೋರ್ಟ್ಗಳಲ್ಲಿ. ಹಾಗಾಗಿ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಕೂಡ ಒಂದು ಮಾಡೋದಾದರೆ ನಾವು ಎಲ್ಲ ರೀತಿ ಸಹಕಾರನ ನಿಮಗೆ ಕೊಡಿಸ್ತೀವಿ. ನೀವು ಯಾವಾಗ ಬರ್ತೀರಿ ಆಗ ಸನ್ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳ ಫ್ಯಾಮಿಲಿ ಶೇರ್ ಏನಿದೆ ಅವ್ರ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ನಾನು ಕೊಡಿಸ್ತೀನಿ. ದಯವಿಟ್ಟು ಆರ್ಗನೈಸ್ ಮಾಡಿ. ಇದಕ್ಕೆಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಮುಂದೆ ಹೋಗಿ ಕೂತ್ಕೊಳ್ಳೋದೇನು ಅಗತ್ಯ ಇರೋದಿಲ್ಲ. ವಿ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ಸಮಥಿಂಗ್ ಆನ್ ಅವರ್ ಓನ್. ಈಗೇನಾದ್ರು ಮಾಡಿಕೊಂಡು ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮಾಡಿ ಪುಲಪ್ ಮಾಡಿ. ಮತ್ತು ಡಿಜಿಟಲೈಸೇಷನ್ ಆಫ್ ಲೈಬ್ರರೀಸ್ ವಿ ಹ್ಯಾವ್ ಟೇಕನ್. ಮಕ್ಕಳಿಗೆ ಡಿಜಿಟಲೈಸ್ ಮಾಡಬೇಕು. ಒಂದು ನಾನು ಸನ್ಮಾನ್ಯ ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಹೈಕೋರ್ಟ್ಗೆ ಹೋಗಿದ್ವಿ. ನಾವು ಹೇಳಿದ್ವಿ ಆಪ್ ಡೆವಲಪ್ ಮಾಡಿ, ಬರೀ ಡಿಜಿಟಲೈಸ್ ಮಾಡೋದು ಬೇಡ, ಮೊಬೈಲ್ ಆಪ್ ಕೂಡ ಕೊಟ್ಬಿಟ್ಟು ಮಕ್ಕಳಿಗೆ ಏನಾದ್ರು ಅದನ್ನು ಆ್ಯಪಲ್ಲಿ ಇಟ್ಕೊಂಡು ಓದೋವಂಥ ಸ್ಟೇಜ್ಗಾರ ತರಬೇಕು. ರೆಫರೆನ್ಸಸ್ಸು, ಭಾಳ ಬುಕ್ಸು, ಕೇಸಸ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸಸ್, ಹೈಕೋರ್ಟ್ ಕೇಸಸ್ ಎಲ್ಲ ಆ್ಯಪಲ್ಲೇ ನಾವು ಬರುವಂಥ ಸ್ಥಿತಿನ ನಿರ್ಮಾಣ ಮಾಡಬೇಕು. ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡು ನೋಡುವಂಥ ಸ್ಟೇಜ್ ಅಂತೇಳಿ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಇಟ್ ಗೋಸ್, ಇಟ್ಸ್ ವಂಡರ್ಫುಲ್. ಮತ್ತು ನಾವು SC ST ಮಕ್ಕಳಿಗೆ ಎಲ್ಲೋ ಒಂದು ಕಡೆ ನಾವು ಸ್ಟೈಫಂಡ್ ನಿಲ್ಲಿಸಿದ್ದನ್ನೆಲ್ಲ ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀವಿ. ಯು ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಅಪ್ ದಿ ಕೋರ್ಸ್ ಸೀರಿಯಸ್ಲಿ. ಹಾಗಿದ್ದಾಗ ಮಾತ್ರ ಯೂನಿವರ್ಸಿಟಿ ಇವತ್ತೇನು ಸೆಲೆಬ್ರೇಟ್ ಮಾಡ್ತಿದ್ವಿ ಫೌಂಡೇಶನ್ ಡೇ, ಅದಕ್ಕೆ ಗೌರವ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಮೇಡಮ್ ಅವ್ರಿಗೆ ನಾನು ನಿಜವಾಗ್ಲೂ ಆಭಾರಿ. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಅಲ್ಲಿಂದ ಬಂದಿದ್ದಾರೆ. ಏಕೆಂದರೆ ನಾವು ಕಾಯ್ತಾ ಇದ್ದೀವಿ, ಫಾದರ್ ಆಯ್ತು, ಇವರೇ ಅವತ್ತು CJ ಆಗ್ತಾರೆ. ನಮ್ಮವರು ಇವನಲ್ಲಿರೋದ್ರಿಂದ ಅವ್ರಿಗೆ ಒಳ್ಳೇದಾಗಲಿ, ಕರ್ನಾಟಕಕ್ಕೆ ಭಾಳ ಗೌರವ ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಅವ್ರು ಬಂದು ನಿಮಗೆಲ್ಲ ನಿಮ್ಮ ಮುಂದಿನ ಶೈಕ್ಷಣಿಕ ದಾರಿನ ಹೇಗೆ ಮಾಡ್ಬೋದು ಅಂತೇಳಿ ಅಡ್ವೈಸ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಭಾಳ ಆಭಾರಿ ಅಂತೇಳಿ ಈ ಯೂನಿವರ್ಸಿಟಿ ಪ್ರೋತ್ಸಾಹಿಸಲಾದ ಜವಾಬ್ದಾರಿಯಿಂದ ನಾನು ಅವರಿಗೆ ಅಭಿನಂದಿಸಿ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ.
Patil, Registrar Evaluation, Karnataka State Law University, to propose the vote of thanks. Please, sir.
It gives me immense pleasure and satisfaction to propose vote of thanks on this momentous occasion. I deem it a privilege to express my deep sense of gratitude to Honorable Mr. Justice B.V. NAGARATHNA, Judge, Supreme Court of India, New Delhi, for providing a roadmap for the future of legal education and its relevance to justice delivery system. Madam, your ideas and innovative thoughts will go a long way in molding the legal education and make it globally competent. On behalf of all the state, Honorable Minister for Law, Parliamentary Affairs and Legislation and Minor Irrigation, Government of Karnataka, and Pro-Chancellor, Karnataka State Law University, for his valuable presidential address. Sir, your words of wisdom go a long way in molding the career of young law graduates. On behalf of all the statutory officers and staff and students, I express my gratitude to you. Thank you. I am happy to express my thanks to Professor Ishwar Bhatt for introducing the guests on this occasion and highlighting the achievements of the Karnataka State Law University. Thank you very much. I take this opportunity to express my thanks to Madam Ratna Varangowda, Dean and Director and Acting Vice Chancellor, for gracing this occasion. Thank you. I am proud to express my gratitude to all the Honorable Judges of the High Court of Karnataka, and more specifically Honorable Mr. Justice Indiresh for gracing this occasion. Thank you very much. I thank Sri Venkatesh Naik, the Principal Law Secretary for Government of Karnataka, for advising us constantly for organizing events like this. Thank you very much. I thank Adiga sir, Principal District and Session Judge Dharwad, for gracing the occasion. Thank you, sir. I thank the judicial officers of Hubli and Dharwad. I thank the esteemed syndicate members and academic council members for their gracious presence amidst us. I thank all the learned members of the bar and distinguished invitees. I thank all the judicial officers of Hubli and Dharwad. I thank Professor Muhammad Jubairian, KS Registrar, for his constant support in organizing this event. I thank all the distinguished invitees, press and media, electronic media. I thank everyone for your gracious presence and making this event a grand success. I thank Madam Vidyavati for gracing this occasion. Thank you everyone for being present here and making this event a grand success. Thank you all.
Punjab, Sindh, Gujarat, Maratha, Dravida, Utkala, Banga, Vindhya, Himachala, Yamuna, Ganga, Uchchala, Jaladi, Taranga, Tava Shubha Name Jage, Tava Shubha Ashisha Mage.